Court of Appeals for the State of Michigan is now in session. The Honorable Seema G. Patel, the Honorable Daniel S. Karopkin, the presiding Honorable Michael J. Kelly. All persons have business here and draw near. Give attention and shall be heard. God save the United States, the state of Michigan, and Honorable Court. Please be seated.
Well, good morning. On behalf of Judges Patel and Karopkin, welcome. We have a very busy day ahead, so we're going to jump right into it here. I think most of you have crossed swords in here before, so you know how this works. I do remind you that if your case involves a minor, please refer to them by their initials rather than their name. The first item is a double case. It is item number 1. First is People versus Pete Musico, and that's docket number 364,467. And it's combined with docket number 364,572, and that's People versus Beller.
Good morning, Your Honors. Jason Eggert from the State Appellate Defender Office on behalf of Mr. Musico. There are several issues here before the court today, but I think the logical starting place is the Morrison opinion that was just issued this past month. Obviously, that is a companion case to this one, and at a minimum, requires that this court enter an opinion in order granting a new trial. As we set forth in our supplemental pleading before this court, we don't think that that should be the limitation on this court's ability to grant relief in this case. First, the court made very clear in Morrison that they were not addressing the question of sufficiency of the evidence. They made it clear that they said that they treated it as an instructional error, and also noted that the defense counsel in the Morrison case had conceded the issue of double jeopardy. So there was no need for the court to reach the question of sufficiency of the evidence or double jeopardy. Now, when dealing with the issue of sufficiency here, I think it's very clear, as we've argued in our supplemental pleading, that the entire case was premised on the kidnapping plot of Governor Whitmer. Any other acts here were simply part and parcel of that. I think, second, when we look at the core holding in Morrison, not the remedy, the issue was that kidnapping is not a sufficient basis to grant relief. That is a finding of sufficiency. And when we look at how the evidence was presented in this case and the manner in which the jury was set to render a verdict, where they were given a general option of guilty or not guilty, told they could use kidnapping, among other alleged terroristic acts, to form their conviction without differentiation, what we have here is a finding that the evidence is insufficient. It's an acquittal on appeal, as we've set forth in the brief. Now, I think what's important to point out here is the prosecutor relies on the Watkins case to say that this panel is bound by Watkins and cannot grant the relief we're requesting for. I think that's simply not the case.
I'm sorry. So are you arguing that, in effect, the Morrison court found insufficiency? Or are you arguing that we should go and look to see whether the evidence other than kidnapping was sufficient? So I think those are two different paths that we could.
Those are two different paths. I think either it could be appropriate, right? I think first, the court clearly held in Morrison that the kidnapping was not a sufficient basis to convict for material support of terrorism because it does not constitute an act of terrorism under the statute. That's a sufficiency finding. We think, based on the facts of this case, the court could look at the issue squarely through that lens and look at it and say, well, this was a sufficiency problem with the charges, the manner in which the evidence was presented in this case, where they said, pick any of these. They were very clearly relying on kidnapping as their primary basis, as we set forth. That's part of the reason Governor Whitmer appeared as a victim at sentencing for victim impact statements. If the crime was, that there was going to be police officers potentially shot or assaulted or some bombing, Governor Whitmer wouldn't have a place to speak at the sentencing because she wouldn't be a victim under the Crime Victim Rights Act. So it's very clearly the case that people were proceeding as if that was the basis of the conviction. Now, the question is whether,
It came up though during the trial, right? And the prosecutor specifically said, no, there's this blowing up stuff and murdering police officers and all that. I mean, she tried to make it very clear that that wasn't the only thing that was at issue.
yeah, I agree with that. I think that's factually very clear. The question is whether you can still seek retrial after presenting a very patently insufficient basis for your conviction. We argue that that should not occur under Evans and the Supreme Court precedent. I think Watkins is important to discuss because that involved something that I think is a very different situation. The court made clear that this was some form of either a clerical error or accidental listing of a substantive count over the other. There was the CSC first count and the attempted CSC second count in that case. And there was also confusion at the trial as what to the appropriate predicate felony was for the felony firearm in that case, where it could have been closer to a jury instruction error or not. It wasn't this grab bag approach that we have here with a general verdict that the jury was required to reach. I'd also note, I don't think the court's required to reach this question, but I don't think Watkins really survives after Evans. Evans made clear that an acquittal, even if it's based on an accident, which it was in Watkins, there was an accidental error of what count are we listing as the predicate felony for felony firearm occurred. Evans made clear that they're not going to get into this hair splitting about what's the appropriate remedy here. It's an acquittal for double jeopardy purposes. But again, I think it's distinguishable on its facts. There's no need for the court to reach whether Watkins is still good law. But I think it's worth noting that there has been a change in how double jeopardy claims are treated post Evans. I also think that, unless the court has more questions for me on the sufficiency thing, I think I did lay out at least our position pretty clear in that brief, and I don't want to give it short shrift here at argument. There are questions, but I think there aren't. There are other issues to discuss here that could impact what the ultimate remedy is, or at least the scope of what any retrial could be. We've argued that there is a constitutional problem with this statute at issue. It lacks the type of guidance that the federal statute has, that it would be amended. And just based on the activity at issue in this case, there is no clarity as to what act of material support the Mr. Musico and others were accused of doing. I think it's worth noting as well that a lot of this activity falls squarely within the First Amendment under Brandenburg and others. Just because it's unpopular speech does not make it illegal. And it becomes even more important for the statute to narrowly look at what those type of circumstances are. I think it's also, as we addressed a little bit earlier, there's no clarity as to what the act is that they were supporting. There's multiple acts at issue, and that creates those types of sufficiency problems. Even though the remedy here, I think, is retrial very clearly under Morrison, I do want to note that the problem with Cooks in this case is fairly egregious. This falls squarely under Gadomski's scenario, where there are multiple acts that could constitute crimes on their own. So kidnapping, murder, bombing, those are all discrete acts that were alleged to have been committed or not to be committed, but were alleged to be in the process of occurring, that there was some material support provided to. Gadomski makes clear that when there are separate crimes, that Cooks is required. And finally—
What's the remedy for that ordinarily? Is that a retrial remedy?
Ordinarily, that's retrial. I think this is not just a Cooks problem, as we've argued with the sufficiency evidence. Typically, a Cooks problem you see, let's say there's three crimes at issues here. All three are a appropriate basis to convict under Cooks. If there's no instruction given, the remedy would be retrial. In this case, what we have is the primary basis for conviction, and the primary thrust of the charges of kidnapping is a legally insufficient basis to convict. That makes it different than just a Cooks problem. Oftentimes, There can be multiple issues that occur in a trial at once due to either a problem with the charges or the instructions. It just so happens that the sufficiency problem in this case can be both, right? Just as it was not a sufficient basis for the jury to potentially convict Mr. Musico based on kidnapping, it was inappropriate for the jury to have it in its instructions, right? But the problem here, and I think the threshold question is whether this is a sufficiency problem, right? Because that dictates the remedy in this case. And finally, with respect to the gang membership count, we've made the argument here that there's insufficient evidence to support that based on the evidence as we have it. All we have in the record is testimony that from Special Agent Impul, I'm sorry if I pronounce his name wrong, stated that he did not find a 501c3 records for the Wolverine Watchman. As we've argued, the statute doesn't say nonprofit corporation. It says a not-for-profit organization, which could include other ones that aren't incorporated under law in the same way, and under the plain terms, there wasn't evidence presented in this case to support a finding of guilt on that count. And that would be something we're suggesting that if this court does not agree with the sufficiency problem in this case, is the broader issue that they would have to address, because it would define whatever the scope of any remand would be in this case.
So what would be a gang that would work? A gang that's trying to make a profit? Is that the only type of gang that you could?
I think under the
work here?
statute, yes. If they limited the application of the statute to it and said not-for-profit organizations don't count, then it's similar to kind of the federal laws about criminal enterprises, right? There has to be some thing about it that could affect interstate commerce in those cases, and usually that involves profit motivations like selling drugs or other types of influences. I think part of the reason we have this issue is, and it's clear from the legislative history, that there was a concern about the type of associational groups that we see in Michigan all the time. Like there's a long tradition of militia groups in our state. They also reference motorcycle groups or clubs. So it was a very clear concern of the drafters of this statute that there needed to be some limitations so it didn't scoop up people that would be otherwise engaged in lawful and constitutionally protected activities. Unless the court has any questions, I'll reserve the rest of my time for rebuttal.
No?
I'm not sure, Your Honor, if you would rather.
What's easier for you? Would you rather reply to this?
If the other appellant spoke, and then I can respond
Okay,
to both.
let's do that then.
Thank you. Morning. So Ronald Ambrose appearing on behalf of Paul Villar. I won't repeat everything that fellow counsel stated, but I will. I do have an independent basis for insufficient evidence argument. And my client has to be looked at differently from Mr. Morrison and Mr. Musico. Those two individuals were relatives. They were in-laws. They were distinctly different from my client. June 28th is a major date in this case. And at that, on that date, there was a training exercise that was conducted. And after that training exercise, there was some extreme language that was said at that exercise. Essentially, if you're not in, get out. And what does my client do the very next day? He goes out. He leaves the Wolverine Watchman on June 29th. And that's the end of his involvement with the Wolverine Watchman. What happens later is even more telling for Mr. Villar, is that he leaves the state of Michigan on July 27th or 29th, right around that. This is well before any type of plan is in place to either kidnap the governor or do any type of terrorist act. There's testimony that there is some concepts being floated around, but nothing concrete, nothing that my client was involved with. he wanted a defensive group, and that's why he left the Wolverine Watchman. When things got extreme, he left. And to lump him in with the more extremists of the group is just wrong. There is no evidence that he did anything to support Fox or Croft in their bizarre and strange and extreme ideas. And rightfully so, those two are in prison. But to suggest that my client did anything to support those two is not factually correct.
Well, there was this June 28th medical training. And I mean, you may quibble over how significant that training was, but it isn't, if on June 28th, he knew that there was an intent or a plot to commit a terrorist act, isn't providing that medical training, such as it is, isn't that material support?
I think this is where the facts of the case become very, very important, because it's the prosecution or attorney generals. I think they posed the idea that this extreme language was before the actual training. It actually happens afterwards, and my client leaves once those statements are made. He had no intent to support such activities.
So you're saying that the problem here is the knowledge as opposed to the support.
Absolutely, yeah, it absolutely is. He had no knowledge that anything was going to happen, and once they started talking about blackbagging politicians, he says, "I'm out." You know, they gave him the option: you're in or you're out. He left. I'm not going to go into the other issues that I have, except for the fourth issue that I raised, and that was this instruction on what the court gave the jury on entrapment. And I thought it was just an unnecessary. If this case does get remanded back down, I would like to have a ruling by this court saying that this instruction is unnecessary and should not be made again, because my client never made an entrapment defense to the jury. And actually, it was his position all along that he did nothing wrong. So in order for entrapment to apply, you have to do something wrong. But the trial court in this case gave an instruction essentially saying, I've already made a legal ruling on this case, and it's not for you to decide, you know, the entrapment. And basically what it did is gave the jury the idea that the government agents were credible. And I think that just went overboard, and it was unfair to my client.
Wasn't that done because the defense lawyers were trying to smuggle in a little bit of the idea that there was entrapment with the mole leading the training sessions and that sort of thing?
It was, okay, it was hard to ignore what had occurred. And the Attorney General's office got in front of it. And initially in their opening statement, in their first witness, they say, you know, this confidential human source, Dan, was paid money. Not only some money, he was paid $54,000. And so they got in front of it, but then, and my client makes no, I mean, it's out there. I think it's fair game at that point to question him about, you know, the money that was received.
I'm not talking about the money. I'm talking about, I think they got into that he was actually leading the training sessions and that he was sitting at the head of the table with Croft and Fox at some of these meetings. And that, I mean, it's all the markings of entrapment were there without using the word or making the argument. My memory in reading the transcript is that that's how that instruction came to be. Am I not remembering that?
Well, it was inescapable that, that idea was out there that because of everything,
Right.
this confidential human source was second in command. So yeah, he's going to be at the head of the table if he's second in command, which violated the FBI's statement that he shouldn't be involved in any type of criminal activity, and he's involved in training. But what I'm saying is that it was an unnecessary instruction. It gave the jury an idea that all these government witnesses were credible. It didn't have to be said. Entrapment there was, from my client's perspective, he never made that argument of being entrapped. And it didn't have to, it was a special instruction. It didn't have to be read to the jury.
Both have time for rebuttal, by the way.
Good morning, Your Honors, Brother Counsel. I am John Pallas, Assistant Attorney General, representing the people of the state of Michigan in this case. I must admit that I find myself in a very odd position given what just occurred in the Morrison case just a couple of weeks ago. So this is far from just a routine oral argument, just as there's nothing routine or typical about a plot to kidnap and possibly harm Governor Gretchen Whitmer, other politicians, killing law enforcement officers who got in the way of their plans, and so on. This is about as serious as it gets. These defendants were hell-bent on helping to start civil war in the United States and wreaking havoc with our law enforcement and political systems. And they almost accomplished their goals if it had not been for the involvement of the very professional FBI agents and other law enforcement agencies like the Michigan State Police that prevented the plot from continuing. But I think what we need to really address, and what the elephant in the room is here, is the published decision in the Morrison case. This panel asked the parties in this case to brief whether it had any impact on this case. In Morrison, a panel of this court consisting of Judges Boonstra, who authored the opinion, Cameron, and Schwartzel, found that kidnapping could not serve as a violent felony for purposes of a charge of providing material support or resources for an act of terrorism. It also held that the jury instructions made matters worse because they allowed the jury to possibly find that the violent felony at issue was in fact kidnapping. If these were issues in this case, I would say that there would be no question but that under MCR 7215J1, this panel would have to follow Morrison's rules of law and likewise reverse Defendant Musicos and Defendant Bellar's convictions. But they're not issues in this case. And I'm saying that is because neither Musico nor Bellar raised these issues in their briefing before this court and didn't do so until ordered to do so by this court after the opinion in the Morrison case was issued. As I noted in my supplemental pleading, this court shouldn't step out of its usual role and address claims that are not raised by the parties. And this is the so-called principle of party presentment, which was even talked about by a recent case in the United States Supreme Court that came out this term. In other words, I'm respectfully asking this court to reject the claim as to Musico and Bellar because of their failure to raise the claim before this court in their prior briefing or otherwise until after the Morrison decision was issued. Of course, the question then becomes what remedy do Bellar and Musico have in this circumstance if they can't raise the issue now? Well, if the Morrison decision survives appellate scrutiny by the Michigan Supreme Court, and I say if, because I think it's no secret that the Michigan Attorney General's office is appealing the decision of Morrison, so it may not be legitimate law for very long. But if we do prevail and the Morrison opinion ends up being law of the land, so to speak, Musico and Bellar can always file motions for relief from judgment in the trial court, raising the issue that ultimately won Morrison relief. But I don't want to make any assumptions that that's the direction that this panel is going to go. So I'm going to assume for the sake of argument that this panel is going to allow Musico and Ballard to raise the issue that won the case for Morrison. As such, I do want to talk a little bit about Morrison's decision and why I believe it was wrongly decided, even though, again, I fully recognize that this court is bound to follow it under MCR 7215 J1. This court can indicate, if it wishes, however, that it is following the decision in Morrison only because it must, and that it otherwise disagrees with that decision. And I cite the court to MCR 7215 J2. And here's just a few of the many reasons why the panel should just do this, should just do that. First, it's true, and I know the opinion in Morrison talks a lot about the changes that were made to the kidnapping statute in 2006, which took out the word force from the statute. I can be honest, I don't know why the state legislature did that. I did a lot of research trying to find that out. It's not entirely clear. It seemed like they were in the process of also creating an intermediate offense of unlawful imprisonment, which is a less serious crime than kidnapping. So that might be possibly why some of the wording was changed. But in our opinion, contrary to the Morrison decision, that does not mean that kidnapping was no longer a violent felony. Far from it. The kidnapping statute, as amended in 2006, now uses language about restraining another individual with the intent to do one or more of the following, and then it goes ahead and lists a bunch of things. Then the statute says that to restrain in this context is to restrict a person's movements or to confine the person so as to interfere with that person's liberty without that person's consent or without legal authority. My question, Your Honors, is this. How does one restrain someone for ransom, use a person for a hostage, engage in criminal sexual conduct with a person, take a person out of the state, hold a person in involuntary servitude, and so on, without exercising some sort of force or violence over the person? It just can't be done. The word force may have been taken out of the statute, true, but that does not mean that the offender does not have to use force or violence to accomplish his or her reason for the kidnapping. In other words, it's certainly implied as an element of each of the types of kidnappings that are described in MCL 75349. Second,
Mr. Palace, what do we do with this fact that the definitions under 543B talk about physical force being an element of the crime of violent felony? So how do I line up the definition, the elements of kidnapping and find physical force and line that up with the definition for terrorism?
well, certainly, Judge Patel, I understand your question. As I was just indicating, I think the element of force is implied in the way the statute is written now. And one of the ways to look at this is to think about a lot of our other statutes that are out there, other violent felonies. There are some felonies that are unquestionably violent, like assault with intent to commit murder or assault with intent to commit great bodily harm. The word force isn't explicitly used in those statutes prohibiting such conduct. And yet I don't think anyone here even would dispute that those are not violent felonies. So I think it's because the force element is implied rather than explicit is why that would make a difference. And to answer your question. Another thing that's important to look at, and I think the Morrison panel kind of mentioned it but didn't discuss it very greatly, is the relationship between the federal and state versions of the anti-terrorism statutes. Michigan's anti-terrorism statute was largely based on the federal anti-terrorism statute, which is replete with references to the federal offense of kidnapping. The Morrison panel says that when the state legislature took out the word force out of the kidnapping statute in Michigan in 2006, the link between the federal and state versions of the anti-terrorism statutes ended. Again, not so. It's still implied. It's still, the Michigan statute is still inextricably linked to the federal version of the anti-terrorism statute, which specifically involved kidnapping as a possible predicate felony. Nothing there has changed. The panel in Morrison was the first of 3 state cases in this matter to issue an opinion, which I think is an unfortunate byproduct of this court deconsolidating Morrison's case from that of the other 2. That panel found kidnappings not a violent felony for purposes of Michigan's anti-terrorism statutes, and thus that Morrison could not be convicted of providing material support for an act of terrorism. The decision is legally wrong and further makes no sense from a logical or common sense point of view. I mean, how can kidnapping not be violent? It just doesn't make sense. If you would ask a citizen on the street, is
But we don't
kidnapping?
ask a citizen on the street, do we? We look at the statute, we look at the language and the definitions.
That's true. That's true. But I think you can take that in the context in which how it sounds, the interpretation that the Morrison panel came up with, that it just sounds implausible. It is, I guess, the point that I'm trying to make, Judge Kelly, and maybe I didn't articulate it well enough. Unfortunately, I've already indicated if the panel considers the issue as to these 2 defendants, this panel has no choice under MCR 215, 7215J1, but to follow Morrison and apply it in Musico and Bellar's cases, which means that their convictions, like that of Morrison's, will have to be vacated, at least for now. Given that there's going to be Supreme Court proceedings on this, there's the court rules that talk about it not being effective until after the Supreme Court has ruled on any applications that are taken. But nonetheless, the fact of the matter is this court is bound. It has to follow it. It may disagree. It can say that it disagrees under MCR 7215J2, that Morrison is wrong, and that it's following it only because it must under the Michigan court rules. This is, in fact, really, with respect to that issue, all that we're asking from this panel to do here. And what we ask.
Yeah, can I ask what, so that rule is usually connected to the part of the court rule that says if we do say that we are only ruling that way because we're bound, then there can be a poll for a conflict panel, and then 7 judges of this, if the poll results in a majority of this court voting to rehear the case, so to speak, and there would be a 7-judge panel from this court that rehears. Is that what you're asking for?
That's yes.
Okay. So let me just ask you a couple of questions about this, because this is a very unusual case in many, many ways, right?
Absolutely.
One of the ways I think it's unusual is that it all, as you just referred to, there was a deconsolidation, but it all springs from one single trial. And it seems to me that if we were to say we disagree with the previous panel and we're only deciding it this way because we're bound, and then if there's a poll and 7 judges of this court hear the case again and agree with you, all that does is it erases the precedential effect, as I understand it, it erases the precedential effect of Morrison, but it doesn't undo the judgment in Morrison. And I say that because then there would be a weird consequence of all of this, which is that Morrison would still be going back for a new trial, and then these 2 defendants would not be. And so you'd have essentially this situation where you'd have different outcomes from the same trial, where the facts really are basically in all material respects the same. And
I
so
agree, Judge.
don't we have kind of a equity? I don't know whether we call it equity or something like that, but don't we have a little bit of a potential problem about the same trial resulting in different outcomes for different defendants?
Oh, absolutely. It's a problem, which is why I think deconsolidation, especially in retrospect, I mean, I don't think anybody saw something like this coming down the road. But that with deconsolidation, that's exactly the potential problem that arose and now has arisen. I think ultimately this whole thing's going to end up in the lap of the Michigan Supreme Court. Because even if this panel were to say, no, we don't disagree with the panel in Morrison, we're bound to follow it. We're going to reverse their convictions on the same basis. Those convictions will also be taken up on appeal by the Michigan Attorney General's office. So ultimately, I think, speaking in terms of equity, to try to even things out and to not come up with some kind of result that just seems absurd, where somebody's getting a new trial and somebody else isn't, I think the Michigan Supreme Court is going to have to step in at some point.
Okay, so if that's the case, I guess I'm wondering why should we, and by we, I mean this panel or the entire court, is it really worth doing more on this as opposed to just saying, you know, Morrison is what it is, and you know, this is all springs from one trial, so we do what the Morrison panel decided and then leave it to the Supreme Court.
Well, as we know, the Michigan Court doesn't take every case that comes before it. Certainly, if the Michigan Supreme Court were to see that kind of thing happening here, whether or not this court explicitly rejects our request or accepts it and says there's a problem here, there's a conflict that we'd like to see resolved. What that does is make this, I think, in my opinion, a more attractive case for the Michigan Supreme Court, who doesn't grant leave to appeal in most of the cases that come before it. So that would be one of the reasons why we would ask for the court to do that, would be to kind of catch the attention of the Michigan Supreme Court. Yet another reason.
Sure, their attention has been caught. This is a kind of a famous case.
Absolutely.
And whether we say that or not, I don't think it'll matter two straws to the Supreme Court. They're either going to hear that or they're not. And
Well,
they probably will.
Yeah.
But back to the conflict, usually that's another opinion comes out that would interpret this. The only one that there is an unpublished one. So what does Morrison conflict with? There's no other case it conflicts with. Just saying we don't like the result?
Well, I think then the conflict would be between the decision of this panel conflicting with the Morrison panel. That's where I would see how I would understand the conflict to be. That would create the conflict that would necessitate all the other steps that would follow from that. So
can I ask just if Morrison had been unpublished, this is just hypothetical, obviously.
Sure.
If Morrison had been unpublished, we'd still be in a slightly strange position, right? Okay, we're not bound by the precedential effect by Morrison, but there's still kind of a law of the case type of situation going on here. It just seems it would be odd to have the two defendants in this appeal have a different outcome on the same exact legal issue.
Absolutely. I totally agree with you, Judge. I think there needs to be, ultimately, it's going to be the Supreme Court's job to try to resolve this. It's, for lack of a better word, kind of a mess that has been created now, because you have a conflict not between cases of involving different situations, but a conflict within the same case, which just doesn't make sense. And again, you're talking law of the case and other concepts like that potentially become involved. So yeah, I think even unpublished would have been a problem on the facts of this case. And given that it's all one trial and these cases were originally all consolidated together to be heard as one appeal, that changed and that led to this odd result of Morrison releasing a published opinion. I believe it was on June 9th. And then here we are, it's July 7th, and we're having oral argument on the other two. It just seems odd. And I'm certainly not going to say and get up here and say that the panel is not bound to do what the Morrison panel did in its ruling. All I'm asking is for it to indicate that it disagrees with that decision. Just a couple of very quick points I'd like to make with regard to some of the comments that were made by my brother counsel. It sounds like what he's saying, and specifically I'm referring to counsel from Musico, is saying, well, yeah, we agree, that part of Morrison that says that kidnapping can't be a predicate felony for an act of terrorism. We agree with that, and that should be followed, but we disagree with the part of the opinion that says that there can be a retrial. I mean, I think that's a real contradiction. I mean, that seems like a strange, take it or leave it, kind of like trying to split the baby. I don't know what expression, but it just seems another oddity that has come out of this case. And I'm not blaming brother counsel. He needs to make the arguments that he needs to make on behalf of his client, but he raises a constitutional question about the constitutionality of Michigan's anti-terrorism statute. I'm not going to go into a lot of detail about that. There's a lot in there in my brief that talks about why I believe that statute is not unconstitutional. Same thing goes for the issue of sufficiency of evidence as to the gang membership felony charge. A couple of things about what brother counsel said about Villar. Yes, it's true. He did leave the state of Michigan at some point, but it's our position that by that point, the crime had already been committed. Everything else that happened after that was icing on the cake, so to speak. So, and it's important to mention too, that the facts indicate that when the police started looking into Villar a little bit, prior to the big takedown of everyone, there was a call or a communication made by Villar to his colleagues saying, hey, guys, be careful, the police are snooping around. So, I to try to say that he cut himself off completely from this, I think is a bit of a mischaracterization of the evidence. And I think as one of the judges mentioned, this Paul Villar specifically did a lot of medical training, including medical training in Cambria, Wisconsin, where Adam Fox and Barry Croft and others attended, and were moving forward with this plot to create boogaloo or civil war within the United States. On that note, Your Honors, unless any of you have any questions, I'll end with that. I thank you for the opportunity to present argument in this case. I really appreciate it, and I look forward to seeing how this court deals with this very interesting issue.
Okay, thank you very much.
Thank you. Thank you.
We'll get some brief rebuttal here.
Thank you, Your Honor. Just to respond briefly to the point that I was expressing disagreement with the Morrison decision, I think that's not the position we're taking. The Morrison opinion is correctly decided. The issue of remedy, however, that we're asking for wasn't before that panel, that they didn't treat it as a sufficiency problem. And the parties both agreed at that time that double jeopardy would not apply. So the court, as it often does, makes a decision that's driven by what the parties put before it. There's no disagreement with Morrison. I think I also want to make clear that this is a situation where why we're asking for that double jeopardy attached is that the verdict cannot be severed at this point when it was kind of mashed together under these theories. You can't say that, okay, well, you can retry on these other counts that were all part and parcel of the same verdict given by a jury. A finding of legal insufficiency is just that. And it requires double jeopardy to attach, and in this court to issue an opinion that would show that. Unless the court wants me to address the issues of the conflict panel, I don't think it's an appropriate thing. There was no conflict, or at least as of now. Quigley was decided in an unpublished case before this, and it squarely decided the issues. And the parties in that case both agreed, based on the amendment to the kidnapping statute, that it wouldn't satisfy it being an act of terrorism based on the removal of the force. And we don't act based on implied elements under the law. They're the elements that are spelled out by the statute. Part of that is to give fair notice to parties that are before it. And just because the federal kidnapping statute might fall within the federal terrorism law does not mean it's the same as our state's treatment of the kidnapping statute. I just don't see a compelling reason for this court to express disagreement or to suggest that there needs to be a conflict panel. I think the decision was plainly decided on what the elements say, and that's the appropriate analysis. So unless the court has any questions, we'd ask the court grant the relief we've asked for in our pleadings.
Trying to find it through the trial transcript, but I wasn't able to. But at least at the preliminary examination, it was referencing to my client and what he did at July 27th. And so the question that was posed to the agent was, so during the time period up until July 27th, they've got some ideas, but they haven't quite figured out what the actual plot's going to be. Is that a fair statement? Yes. So there wasn't a plot in place at the time my client left for the state of South Carolina. So I just wanted to make that point. I think that's also reflected during the trial transcript. I just couldn't pinpoint the actual.
I remember that being brought up at the trial, but I think they said they misspoke or something, but it's a very legitimate point you bring up, but
yeah.
And I don't have the thing in front of me, but my memory was that was.
I think it's pretty consistent to what it was said at the time of trial. There wasn't not a plot in place at the time my client left for the state of South Carolina.
What about by the time he got back in touch and said, hey, you guys need to be careful here. There's a informant or whatever.
Well, yeah, if that's considered material support, then I just disagree with that. That's just, hey buddies, a guy came over, he's sniffing around at my place. You might want to,
I mean, it's different, obviously, than providing medical training, but.
Right. Yeah, I just don't see that as providing material support. All right. Thank you.
Case will be submitted. Brings us to item number 2, docket number 362096, People versus Badur Mohammed Ali Al-Yassari.
Good morning. May it please the court, Ali Wright from the State Appellate Defender Office on behalf of Ms. Al-Yassari. I'd like to focus my argument today on the first claim raised in Ms. Al-Yassari's brief on appeal with respect to trial counsel's failure to have her co-defendant or boyfriend, Mr. Fisher, declared unavailable. But of course, to the extent the court has questions on any of the other issues raised in the brief, I'd be happy to answer them. When I argued Ms. Al-Yassari's motion for a new trial before the trial court had the following question for me. Do we know, or does the trial court do we have a clear direction of what trial counsel's strategy was in this case? And the trial court proceeded to ask me, you're asking this court, the trial court, to tell me, or to whether he had the right strategy, but you're not telling this court what that strategy is. And I really think there is a mechanism to answer that question that the trial court had, and it's a Ginther hearing. That's what Ginther hearings are for, to answer that question, that what was trial counsel's strategy here? And that is precisely what Ms. Al-Yassari is asking this court for today, for this court to remand her case to the trial court for a Ginther hearing to answer that question that the trial court had, because I too struggle with that question. I really think that underscores the need for a Ginther hearing. I too struggle to understand the strategy behind trial counsel's decision not to have Ms. Al-Yasari's co-defendant, her boyfriend, Mr. Fisher, declared unavailable, and for his testimony to be read to the jury in her case. It's not simply reasonable for a defense attorney to decline to present testimony from the only eyewitness to a murder when he knows with 100% certainty, verbatim, what that eyewitness's testimony will be, and that testimony supports his client's innocence. It's undisputed that Ms. Al-Yasari did not personally kill her husband. And the prosecutor, we all agree on this, that the evidence shows that she was across town at the time that this murder occurred. Instead, and again, the prosecution of the government doesn't dispute this either, Ms. Al-Yasari's case is purely about whether she essentially instructed her boyfriend, Mr. Fisher, to kill her husband, or whether she conspired with her boyfriend, Mr. Fisher, to commit a murder that she was not present for. By the time of Ms. Al-Yasari's trial, Mr. Fisher had already been tried separately 3 years prior. He had testified in this case, and he had been convicted of this murder. But Mr. Fisher testified that he alone killed Ms. Al-Yasari's husband, and that Ms. Al-Yasari did not instruct him or conspire with him to do so, that she thought he was going to have a conversation or speak to her husband on her behalf, and that she did not know he was planning to threaten her husband, harm her husband, or that he was even bringing a weapon to said conversation. Now, naturally, I think any defense attorney would want to present this testimony at Ms. Al-Yasari's separate trial. After all, it supports her innocence in this conspiracy case. But Ms. Al-Yasari's jury never heard that testimony from Mr. Fisher, the only eyewitness to this crime and the undisputed perpetrator of this crime. And the question is why? Why did they not hear that testimony from him? Now, the trial court and the prosecution or sister counsel, I really do think kind of throw the kitchen sink at the wall here, and they do manufacture reasons for trial counsel. And I'm sure you saw this court, the members of this court saw many of those reasons in the briefing, and I'm sure you'll hear many of those reasons that have been offered or made up or generated by the prosecutor shortly. But again, none of those reasons are what trial counsel said to me when I spoke to him on the phone. The prosecution cannot circumvent Strickland or thwart the need for a Ginther hearing or an evidentiary hearing by making up reasons that not just fall flat, but most importantly are inconsistent with the reasons that trial counsel has offered. And I really do think this court, I'd refer this court back to our Supreme Court's decision in Trachtenberg that a court cannot insulate from review a counsel's performance just by calling it strategy. It's undisputed that Mr. Fisher was on the defense's witness list, that a writ was prepared for his transport to testify in Ms. Al-Yasari's trial, and that on the first day of Ms. Al-Yasari's trial, trial counsel asked for his name to be read to the jury. As reflected in the offer of proof when I spoke to trial counsel, he informed me that he met with Mr. Fisher in prison shortly before the trial, and Mr. Fisher told him that he was represented and that he would not be testifying, that he would refuse to testify if he was called to the stand. So that's why trial counsel did not call him, because Mr. Fisher was going to plead the fifth. And not what, yes.
The offer of proof said, the offer of proof doesn't exactly say that. As I read it, counsel does say that that Fisher said he was going to invoke the fifth. He was called. That's in the offer of proof. But the offer of proof doesn't say, had I only understood the rule MRE 804, had I only understood that I could have gotten that in, I would have pursued this other line. And maybe what your position is like, well, that's what a Ginther hearing is for, to ask that question. But it seems like we don't really know what it, I mean, I think even assuming trial counsel didn't understand that he could have possibly gotten the prior testimony in, I don't think we know that he would have actually gone that route. And maybe your argument is, well, that would be the only professionally responsible route to go. But I'm a little hung up on whether that was really what made the difference in the strategy that he decided to employ.
Sure. And so I think to go back to, you kind of alluded to it, Judge Carabin. I mean, that is what a Ginther hearing is for. I think we can get into that a bit more with trial counsel during that hearing. When I spoke to him on the phone, we kind of discussed some of this stuff. But I think a Ginther hearing will, one, make a record of that, but two, more importantly, flesh that conversation out or flesh those reasons out more than the affidavit currently does. And so that's one of the reasons we're asking for, or not the affidavit, the offer of proof does. But so that's one of the reasons we're asking for that. But I do think logically speaking, when we have the situation where, co-defendant boyfriend testifies in this conspiracy case, your client knew nothing about this, I do think there's a very serious question. Well, given that he's made very clear to you, I'm not going to testify, why you would not present that information to the jury, why you would not have the transcript read. And that's particularly so given that there's minimal risk. There's minimal risk now to the defense. There's no risk of his testimony changing. You know exactly what his testimony is. Trial counsel already, essentially planned to call this witness. He met with him. He was meeting with him for a reason. He was meeting with him because he was going to plan to call him as a witness. He had him on the witness list. And the only thing that changed was the decision, well, I'm not going to help you out one way or the other. The prosecution could have also called Mr. Fisher too. They chose not to do that too. He was not going to help anyone. And so when you are left with his transcript and the four corners of his transcript, I think that's where it really becomes a question of the reasonableness or the strategic call or the lack of a strategic call to not present his testimony to the jury.
I mean, as I see it, there are a couple of there are going to be some challenges there to bring in that testimony. One is that he says that your client opened the garage door for him, essentially, so that disarmed the alarm, so they could go and talk to the victim. So, on the one hand, he's saying, oh, but she had no idea that, I was going to kill him. But on the other hand, like that's pretty damaging testimony, right? That she knew he was going to go talk to the victim. And so here in the trial that actually occurred, right, the strategy was, let's just not admit any of those things, and we'll pass down on whether Fisher actually committed the murder at all. So I guess, and maybe this goes to prejudice rather than deficiency, but it does seem like there would be some real weaknesses in the path that you're suggesting defense counsel should have taken.
And I think those weaknesses should be also weighed against certain strengths. The strength of the person who says, I killed this man, saying that your client knew nothing about what he's going to do. That's also consistent with Ms. Al-Yassari's, her affidavit and her position in this case, which was not presented to the jury and was really harmful to her, which is that she was letting Mr. Fisher in for this conversation with her husband, that she did not know he had a weapon, did not know he was going to harm her husband or threaten her husband, let alone kill him. And so when that came out, came out without any context, without any of this context. And I think that was super damaging to Ms. Al-Yassari's trial here. And I think given that there was a way to contextualize that conduct of hers of disarming the security system, I think that's something that trial counsel really needed to do, particularly given that he had it in black and white in a transcript from the person who admitted to doing this killing.
Counselor, given that we're dealing here with a potentially unavailable witness and we have the transcript, which is the four corners of what that testimony would have been, why do we need a Ginther hearing to flesh out a possible theory or not a theory? Isn't there enough on the record for us to evaluate the ineffective assistance of counsel?
I mean, I don't quite think so, Judge Patel. I do think we need again the hearing because again, the question is, I mean, the trial counsel had the four corners at the transcript. Of course, this court does too. We all do. The question is, okay, he knew that. Why did you not use it? And I don't think the transcript to answer the question for us, why did he not use it? Now, of course, we can speculate about why that may be. And, you know, sister counsel does that. The trial court did that quite a bit. But one, I don't think those speculations or reasons were consistent with at least what I heard from trial counsel when I spoke to him. But two, most importantly, the transcript doesn't answer the question of, you have this transcript. Why would you not want to present this to the jury? And I think that's very important because trial counsel, again, had Mr. Fisher on the witness list, was kind of going down this route. And it's still perplexing to me why he would not continue down that route when he was going to be, he was trial, and I think this is also an offer of proof. Trial counsel knew exactly what Mr. Fisher testified from his trial. So, and he was still placing him on his witness list, was still going to essentially call him as a witness in this case. So given that he knew that in advance, when Mr. Fisher said, well, I'm not going to testify, you're going to just be stuck with my transcript, essentially, I think that's the question we really need to get at here. And I think that is why we need to ask trial counsel to make a record of this through hearing. I don't think that's answered by the transcript in and of itself. So I guess with that, I know we touched briefly upon prejudice, but I do think that's why we need again to hearing. It's clear that trial counsel wanted to call this witness. It's unclear why he did not to move to have him declared unavailable. And this court, and I believe Ms. Al-Yassari deserved the answer to that question before she spends the rest of her life in prison.
All right.
Thank you.
Thank you.
Good morning, Your Honors. May it please the court, Kayla Crino appearing today on behalf of the people. For Al-Yassari's Eighth Amendment argument and her sufficiency and great weight arguments, I will rely on the comprehensive brief that I filed in this court, but I would like to today briefly address both of her ineffective assistance of counsel claims. So as to Al-Yassari's claim that her trial team provided ineffective assistance of counsel by not having Jacob Fisher, her co-defendant and co-conspirator, declared unavailable and moving to admit his transcript under the court rule, this argument essentially fails for three reasons. First, the court rule requires unavailability. So if the claim is that trial counsel should have utilized MRE 804B1, then the baseline of that inquiry is showing that the witness involved would have been unavailable to begin with. So when Al-Yassari, as part of her appeal, claims that the people's insistence on the foundational requirements of the court rule that they are invoking be met as a part of a Strickland analysis, that is not, as Al-Yassari claims in her reply brief, a misunderstanding of anything, factual or legal. That is holding Al-Yassari to her burden of showing that the Strickland factors are met. This is no different than, for example, claiming that a trial attorney was ineffective for failing to admit an item of evidence through a hearsay exception. The very first step of that inquiry would be showing that that hearsay exception even applied. And at most, all anyone can say right now is that Fisher certainly might have been declared unavailable. We don't know if he would have persisted in claiming unavailability. We don't know if he would have changed his mind and agreed to testify if faced with the possibility of his transcript being utilized. And we don't know what the prosecutor would have done in response. So in terms of claiming that he was truly unavailable, at best, all we can say right now is that he might have been. But what if, as Al-Yassari claims on appeal, trial counsel did not even consider, for whatever reason, utilizing the court rule? Well, how does that factor in? And my answer would be that it does not change anything. If the rule does not apply, then ignorance of it, failure to consider it, does not and cannot ever fall below an objective standard of reasonableness. The second reason that this argument fails is that even if we assume that the court rule applied and that admitting the transcript was a viable option, not relying on Fisher, whether through his own testimony, as Al-Yassari originally claimed, or through a transcript, as she now claims on appeal, was a very sound trial strategy. Under Strickland, the defendant must show that trial counsel's performance fell below an objective standard of reasonableness and that there's a reasonable probability that but for counsel's errors, the results of the proceeding would have been different. And Strickland further requires that the court must, quote, determine whether, in light of all the circumstances, the identified acts or omissions were outside the wide range of professionally competent assistance. And I highlight that language here to inquire, was the defense team here allowed, as part of that wide range of professional assistance that was possible here, to pursue a defense that was not centered on Fisher, or was the only way to provide professionally competent assistance here going with what Fisher said? And there are many, many reasons why not calling Fisher to testify and not using his transcript was a good decision and sound trial strategy. And it does not matter, as has been claimed here on appeal, whether any of these reasons, which are very obvious from the record, were actually considered by Mr. Abood or the rest of the defense team. Now, the inquiry might be quite different if a Fisher had been extraordinarily credible, or if his testimony had actually aligned with the rest of the evidence, or if based on his own testimony, his jury had acquitted him. Then it is possible then, under those circumstances, we would want and even maybe need to know what was in counsel's mind. But that was not what we had here. And contrary to Al-Yassari's claims on appeal, this court is free to look at the record and free to decide whether an omission was within those wide range of professionally competent assistance that could be provided here. To claim otherwise, as Al-Yassari does on appeal, presents an extreme deviation away from Strickland's mandate to examine whether the identified omission was outside the wide range of professionally competent assistance. And there's nothing wrong with the people, the trial court, or this court, with the help from the record, opining as to whether a chosen strategy, in this instance, the omission of the use of the transcript, is within the wide range of competent assistance in this matter. Fisher's testimony in any form was unbelievable. It did not align with the physical evidence of the case, and it was an obvious effort to absolve himself and Al-Yassari, who was still in a relationship with. And though he was clearly trying to help her, the testimony involved many elements which were inculpatory and harmful to him at his own trial and would have been harmful if utilized for Al-Yassari's trial. First, failing to admit Fisher's transcript did not fall below that objective standard of reasonableness because Fisher's testimony was not believable enough to exonerate him at his own trial. The jury not only convicted Fisher of first-degree premeditated murder, but also of conspiring with Al-Yassari to commit first-degree premeditated murder. Second, Fisher's trial transcript confirmed and corroborated critical components of the prosecutor's case against Al-Yassari. Many of those things have been mentioned already here today. Al-Yassari's Al-Yassari's trial included additional proofs that Fisher's trial did not, and this is critical because combining those proofs with Fisher's transcript would have been incredibly detrimental to Al-Yassari's defense. It would not have helped it. Al-Yassari's trial included her interview, which a previous panel of this court, including Judge Kelly, summarized in great detail as a part of an interlocutory appeal. In the interview, Al-Yassari actively impedes the investigation. She refuses to share anything she knows about how her husband was murdered, which, according to Fisher's testimony, if you pair it with that fact, according to Fisher's testimony, at that moment, she already knew all about it because he had called her and told her that he ended her husband's life. During the interview, we see her feign distress, ignorance. We see her giggle at times. We see that she doesn't want the police to look at her phone, and she completely omits mentioning that she, if Fisher is to be believed, turned off her security system so that Fisher could talk to Amar. Al-Yassari's trial also included Exhibit 235, the postcard, and this is not just about the contents of the postcard, it is about the timing of the postcard. It was sent after Fisher's trial began, but before he had testified. And in context, it appears to be encouragement that is directly related to his trial testimony. A jury could have reasonably viewed the postcard along with Fisher's transcripts as showing that they remained in a relationship despite the fact that Fisher had chopped Amar to death with an axe based on her encouragement. As to prejudice under Strickland, Al-Yassari has failed to establish prejudice. There's no reasonable probability of a different outcome had Fisher's testimony been utilized. Fisher was not credible enough in his own trial to exonerate himself, and there's no reasonable likelihood it would have been any different for Al-Yassari's trial. And Judge Dragonchuk, who heard Fisher's testimony, agreed, and she even took it a step further. She rejected the defendant's claim that Fisher should have been called as a witness, and in doing so, she opined that the more difficult question would have arisen if trial counsel had called Fisher to testify and if she had to decide whether trial counsel was actually ineffective for calling him, presenting and centering the very evidence that on appeal, defendant continues to claim should have been utilized. Now, moving on and just briefly addressing the ineffective assistance of counsel argument as to the advice provided by counsel, led by Andrew Aboud. In Al-Yassari's first motion for new trial, she argued that Mr. Aboud was ineffective for advising her that she was stupid or an idiot if she wanted to testify, and Judge Dragonchuk rejected that argument. For the second motion for new trial and the appeal, the argument has changed somewhat, and she claims that her team was ineffective for not advising that without her testimony, the jury would not hear her claim that she turned the security system off so that Fisher could talk to Amar. Now, Al-Yassari claims that if she had known that, she would not have waived her right to testify. Even assuming that the team failed to explain this, Al-Yassari cannot establish that she was prejudiced by this advice or the fact that she did not share this claim with the jury. First, Al-Yassari did not always claim that the defense would involve Aboud in closing that turned her security system off so Fisher could talk to Amar. This claim, it is belied by the opening statements in this matter. So in opening statements, Dan Eckert informed the jury that the prosecutor would not be able to prove beyond a reasonable doubt that Fisher murdered Amar, and that even if they did, they would not be able to prove that Al-Yassari was not involved. Eckert even went so far as to argue that the prosecution would not be able to show that he was coming over to kill her husband and that there was a routine of turning the alarm off sometime after work. So when Al-Yassari claims in her affidavit that she did not know what the defense was going to be until closing, and she didn't know how they were going to utilize the security system evidence, well, that's not true, because Dan Eckert laid it all out in opening statement. So she knew exactly what the defense was going to be at that time. Second, Al-Yassari waived her right to testify. It was a valid waiver, and she acknowledged that it was her choice to waive, regardless of what her attorney said. Third, even if Aboud or the trial team did fully fail to explain that they would not be arguing that Al-Yassari was claiming she turned the security system off so Amar could talk to Fisher, and even if Al-Yassari relied on that advice in waiving her right to testify, Al-Yassari must establish that had she testified, that she disarmed the home so that Fisher could merely talk to Amar, that there is a reasonable probability of a different outcome, not her making a different decision as to whether she would testify. And this argument fails for all the same reasons that the previous argument fails. We don't have to wonder how it would have gone if the jury had heard that claim. It was a lie, and adding another lie, even one made through Al-Yassari's own testimony that essentially mirrored what Fisher's testimony would have been, would not create a reasonable probability of a different outcome. And with that, I'm pleased to answer the court's questions about anything else related to this case. And if the court has no questions, I would just ask that the court affirm.
Thank you.
Very
Thank you
good.
very much.
I know how much time it takes to review a case like this, and I appreciate all of the time and effort I know that this court has put into this matter. And I just thank you for the opportunity to argue here today. Very good.
Rebuttal?
Just a few points, Your Honors. Sister counsel, I guess, raised that the court rule, I guess 804A2, I want to say, requires Mr. Fisher to have been declared unavailable. And I think that's kind of a lot of part of the point here is that trial counsel was ineffective for failing to even go through that process in the first place, failing to move the trial court under 804 to have Mr. Fisher declared unavailable. So I think this is a bit of a, I don't want to say a circular argument or putting the cart before the horse, but part of the ineffectiveness here is not asking or not invoking that court rule in the first place. And I don't think that can really be attributed to Ms. Al-Yassari when we're saying that's kind of the basis for the ineffectiveness. Sister at counsel also argued that we don't know if Fisher would have changed his mind had he been declared under or had he been called in under 804. And nor do we really know what the prosecution would have done in response. And I think this comes up a lot in ineffective assistance of counsel cases. I think the court, I'm hoping the court is very careful here. I think the court needs to be careful in terms of how many rabbit holes we go down and or how many chess moves we do. I read Strickland as kind of one chess move. Trial counsel did not do this, but for that, there's a reasonable probability of a different outcome. I think we can't get too hung up on, well, if trial counsel had done this, well, then the prosecutor is saying they would have done this. Because then once the prosecutor says, well, I would have done this, then the defense can say, well, if the prosecutor had done this, then we would have done this. And then you just go down, it's kind of a spiral
We
to the bottom.
understand, yeah.
And then I guess lastly, or I guess two more points, Fisher being convicted at his own trial. I think as even the prosecutor pointed out, there were different proofs in these cases. These are different juries. There are different foci between the two cases. I don't find that Fisher being convicted in his own trial to be dispositive of what Miss Al-Yassari's jury would have done in her trial. And then lastly, I guess with respect to Miss Al-Yassari's second argument about what her trial counsel told her in advising her about testifying, that opening, I think it's important to remember Miss Al-Yassari is a layperson. So while it's obvious to your honors or to me, even me as an attorney, how things can be established in court, what an attorney can argue in either their opening or their closing based on the evidence. I don't think that it was Ms. Al-Yassari saying that it was not made clear to her that by not testifying and that when they decided that Mr. Fisher wouldn't be called, that that her story wouldn't get out there in terms of the reason I shut off the security system was for this conversation. That was not made clear to her, and that kind of changed a lot for her. And so that's why her decision not to testify is not knowing or intelligent. And sister counsel focused on the opening and how that should have signaled to Ms. Al-Yassari that wouldn't be part of the case. But I think if the court looks at that opening that was delivered by trial counsel, it kind of keeps everything very open-ended. It keeps everything open-ended.
Open-ended.
Yes. Open-ended in terms of where the case is going to go, what they're going to argue. So Fisher was the Fisher angle was not foreclosed. In fact, they still hadn't decided whether or not they were going to call him or and have him present testimony. So they kind of, the opening is broad. The opening still allows this avenue where Ms. Al-Yassari thought that this strategy would be pursued. And I think the issue here is really the base issue of trial counsel not having a conversation with her about how they were going to meet her objectives. If there's no other questions from the court. Thank you.
Thank you. Case will be submitted. So item 3, docket number 369317, People versus Timothy James Edwards.
Good morning.
Morning.
Mitch Foster for Timothy Edwards. And Mr. Edwards will be known as TJ, just because that's how he's referred to, and that's how I referenced him in the brief. So first and foremost, the trial court judge at the conclusion of the Ginther hearing in his opinion, used the wrong standard for the Strickland standard. He said that more probably than not would have affected the outcome. So right away, that's a problem. And as you know, of course, the standard is a reasonable probability, is a probability sufficient to undermine confidence in the outcome. So there's a big distinction. You don't have to get to a preponderance, which the trial court clearly indicated that he didn't find by a preponderance. So right off the bat, this court could remand to the trial court for a new opinion to strike the old opinion and have the trial judge evaluated under the proper Strickland standard and retain jurisdiction, of course. But if the court chooses not to do that, I believe there's sufficient issues that I've raised that require a new trial. Let's talk about MRE 106. This is not an all or nothing. The court rule indicates that select portions of the statement can be used to supplement what is in evidence, but it doesn't say you have to play all of it, because when you get to trial strategy, the defense counsel didn't want to include other accusations made by the state police trooper about other issues of physical abuse that he questioned TJ about. So I think it's apparent that the trial counsel thought it was an all or nothing thing, and that was the reason why he didn't present any additional evidence from the statement. But worse than that, when asked specifically about why he didn't present TJ's portion of his statement about, was there this sit-down meeting where he was told he had to leave the home? Multiple times, TJ said, no, that didn't happen. I just left because I wanted to. He never was told, he never said there was even a meeting and that he was told he had to leave. And that's a critical part that's left hanging. And defense counsel had the ability to present it to the jury, and he didn't. And then when asked about it, I questioned him, and his only answer was, well, I wasn't concerned about it at the time. So that's not a matter of trial strategy. That's a matter of no strategy. Just wasn't even on his radar. He may not have even known he could have brought in that other evidence. Select portions. He might have been thinking all or nothing. And I don't want to bring in the part about the other acts of child abuse allegations, which is reasonable strategy, but he may not have known that you don't have to do all or nothing. You can present select portions, and fairness ought to have been considered. And that's exactly, so I believe that is sufficient reason alone to grant a new trial. But when you look at the cumulative effect of all of the errors, that would be a strong contributing cumulative effect. And those statements, well, there's two arguments that they're admissible. Number one, there's a conflict between hearsay and 106, whether it's admissible, as a hearsay problem. But I don't believe that, number one, it was hearsay, because it wasn't for the truth of the matter asserted. Primarily, the primary reason to get those statements in is out of fairness and to put the statement that was admitted into context. So for hearsay, you can say everything is for the truth of the matter asserted and is considered hearsay, unless there's an exception, but still it would be hearsay. But the real way to look at it is, what's the primary reason for admitting it? Even though a lot of them arguably can be, or maybe all of them are for the truth of the matter, because you're trying to get a statement in that says what it appears to say. But the primary reason here is fairness and to put the statement in context. And that's what this court should focus on. And I believe in my reply brief, I focused on, I responded to the Herndon case and that just says that there's no requirement that the entire recording would be admissible. And it just lays out the law that selective portions can be submitted. And Herndon criticized trial counsel for failing to even identify which specific portions. It was kind of like a all or nothing case. All of it should have come in. And there was no analysis as to which should have come in, which shouldn't, and all of that. Here we have specifically identified portions of that statement that should have come in. And it's especially more important because the defendant, TJ, did not testify in his own defense. So this would have been the only way to get it in. And even though the trial judge might have said, you can't have your cake and eat it too, you can't not testify and still get this in, well, that's completely wrong. You can get it in if it's for a proper purpose, such as out of fairness to put things in proper context. Now, one of the other reasons, of course, is the motive. And trial counsel decided, number one, he's going to say, well, this appears to be a family dispute in his opening statement, very short opening statement, maybe 2 or 3 paragraphs. And he references it twice, a possible family dispute, but then he never introduces any evidence of the family dispute, even though he's got one strong witness as to what this family dispute was and the threats and the motivation. And I believe she testified that the mother of the 2 children told Lori, you're going to pay and we're going to go after your son. And then this was when they were in Florida. A week after they returned to Michigan, the mother who made the threats goes to the police or goes to CPS, and later the police picked up the case. So that she was following through on her threats, and the threats were testified at the Ginther hearing. Now, the trial counsel and an investigator, they did some investigation, but really didn't go into detail about investigating any of the threats or any of the dynamics that were happening when all of these people were living in Florida and how the relationship, fell apart. And these people were eventually kicked out, and then the retaliation, not more than a week or so later when they got back to Michigan. And that's especially important when you look at the timeline, because these allegations going back 5, 6, 7 years, and they could have made a report in Florida. They could have made it earlier in Michigan before they went to Florida. But it was only after the threats and everything fell apart in Florida, they come back to Michigan. The mother goes to CPS. And then we also have, I believe, the daughter complainant, Kay, they're both Kay. The daughter complainant said that she was going to back up her brother. So that shows you, well, maybe that wasn't necessarily, that was her motive, not necessarily to give truthful testimony of what really happened, but she's going to back up her brother. They stick together.
My understanding from the Ginther hearing was that trial counsel did discuss many of these things with the witnesses and then concluded that they just weren't credible. Is that an accurate, is that right? And what do we do with that? I mean, usually it seems to me that if trial counsel thinks this is not going to play well with the jury, that's kind of it, right?
Judge Kropkin, yes, in a sense. However, under Trachtenberg, there wasn't a sufficient investigation. They kind of just fluffed it off at the beginning and never really focused on that. They focused on whether there was, I think he brought in an expert to evaluate the child's testimony and kind of went around it a circular way, like, well, there was no corroboration of some conspiracy, but there was never that didn't come up at any of the child interviews. So it wasn't that it didn't happen. It was, that was the limited circumstances which they gave this expert to testify to. And so I think that's a sort of a different angle they were coming at. But the trial counsel and his investigator didn't look into these head on and really interview the mother, the grandmother, I guess, step grandmother of these two children, really to delve into that specific issue and the threats. And the important thing here is that if that was true and that was a valid strategy, why bring up the fact that there was a family dispute in the opening statement if you're not going to put some meat on the bone and say, well, this is where we're going. But I guess now that I think of it, in the midst of trial, we're not going to present it that way. So I guess you could say it was strategy after the opening statement, which is a flawed strategy and flawed methodology, because you've got the jury wondering what's going on with this family dispute. I guess there really wasn't a family dispute. I guess there is no motivation. So the jury never heard any motivation. Regardless of whether you believe it or not, or parts of this acrimony, the fact that the jury, it wasn't even on their radar, left them without a reason to say, well, this is why. Maybe this is untruthful. And we don't have to prove, of course, by a preponderance. This is just a reasonable probability. It undermines the sufficiency of the outcome of this case. Why wouldn't you present that? I mean, I've tried a few of these CSC cases, and I found that if I don't present a motive as to why this person is accusing the defendant, I lose. But when I do have something like a motivation, like a child custody, like a revenge, like something like that, I win. You know, nothing's 100%. You don't win all the ones that you have a motive and lose all the ones that you don't. But generally, that's the way it goes. And these cases are tough. And when you have a defense and a motive, but you don't present it, that's deficient conduct. And I think it does undermine the outcome. But that's just one of the pillars of the defense, and under the cumulative effect, even though I believe it stands on its own, when you add it to the other two, the other one being the character evidence, there was an argument by the trial counsel that, well, I didn't bring in character evidence because he had this financial transaction device conviction that would have undermined his truthfulness. But the defense wouldn't have presented character evidence for TJ's truthfulness. Number one, he wasn't going to testify in his own defense. So his truthfulness and the truthfulness of his testimony can't be impeached. But even if, but regardless of whether he testified in his own defense, you can't impeach someone's lack of sexual morals with evidence of untruthfulness. They just don't fit together. So it wouldn't have even been relevant. It wouldn't have been admissible unless there was some, I think the argument was, well, if they open the door, one of the witnesses said, well, he's a truthful person. Even if they did open the door and they impeach his truthfulness, they're not going to impeach his character for not being a sexual deviant. So I think that that's a flawed argument that really doesn't matter when you're looking at trial strategy. And the character evidence would have been admissible. As I point out in the brief, there was CSC2 and CSC1 charges. So CSC2 requires a sexual purpose. So that would have been a pertinent trait of character. This, of course, was a combined trial with all the counts. There wasn't a trial for CSC1 and separate trial for CSC2. So that would have been admissible to the jury under that. The People versus Moore case, the unpublished case, was cited by the Attorney General, but that case only involved CSC1. There was no CSC2, so that issue of pertinent trait wouldn't have even, it's not even relevant, and it's unpersuasive and not on point with what we're dealing with here. And finally, the threats. There was argument that maybe they're not admissible. Well, of course they're admissible. Number one, the right to present a defense is a due process right. And number two, even if they're argued that they're hearsay. Well, we've got, you're going to pay under those circumstances. That's an excited utterance of, I can't believe you're doing this. You're going to pay. We're going to harm your son. These are all statements out of anger, showing an excited utterance. Also shows the then existing emotional state of mind and motive. So clearly those would be admissible, those threats. They were never presented to the jury and denied Mr. TJ a fair trial. If there's any other questions?
I don't believe so. Thank you.
Thank you.
Good morning. May it please the court, Assistant Attorney General Daniel P. Kelly on behalf of the people. Mr. Edwards bears the burden to show both a deficient performance by trial counsel and a reasonable probability of a different outcome. On this record, including a very lengthy Ginther hearing, he cannot meet either prong. Let me begin with the theme that binds all three of Mr. Edwards' sub-arguments for ineffective assistance. Trial counsel made reasoned, strategic decisions grounded in the rules of evidence and considering the risks of opening the door to damaging information. The record supports these decisions at every turn. First, I would like to address the issues with respect to character evidence or failing to present character witnesses. Trial counsel was not ineffective or deficient for deciding not to present these witnesses. Mr. Edwards' witnesses or proposed witnesses, his mother, his father, his sister, and his cousin, they lacked the foundational requirements for reputational testimony. And their opinions were rested on sporadic contact and a personal belief rather than his reputation or reputation in the community. Trial counsel testified during the Ginther hearing he was concerned reasonably that each would stray into he's a good person testimony or he's a truthful person testimony, which could potentially open the door for impeachment with his previous conviction for a crime involving dishonesty. But what I'd also like to point out is under MRE 404B, it does not permit specific acts here because character is not an essential element of the criminal sexual conduct, either first degree or second degree. Now, the people in their brief did cite as persuasive, not binding on this court, People versus Moore, an unpublished opinion. But as I was preparing last night, and I wish I'd found it sooner, there's also People versus Canary, Knary, also unpublished, a March 18th, 2025 case, a very recent docket number 336174 at page 3, that says in that case, character is not an essential element of the crime or offense of criminal sexual conduct in the second degree. So in either case, there is persuasive authority out there to indicate that character is not an essential element. I wanted to make sure that I addressed that for the court. So although not binding, these persuasive authorities support the position of both the people and the trial counsel that specific instances of Mr. Edwards's contact or performance around children would not have been admissible. Moving on to the, unless the court has questions about character evidence, I would like to move on to the motive to fabricate. Thank you, Your Honor. The conspiracy argument and or motive to fabricate also fails at both prongs. Again, very lengthy evidentiary hearing on this. Mr. Edwards still cannot show that the trial counsel actually knew at the time of trial the specifics of what his mother alleged was going on, although she did testify she gave a binder or a folder of evidence to trial counsel. Trial counsel described her information as convoluted and confusing, lacking in detail, and even the trial court, kind of a lengthy colloquy with that witness, mother, stated, ma'am, I don't know what you're even talking about here. We've got something to the extent of we've gone on for 20 minutes. I don't have any details of when this happened, what happened. There's just no credibility, and that credibility determination was appropriately made by the trial court. On the records, counsel's decision to avoid presenting the unsupported and potentially harmful conspiracy theory was exactly the kind of reasoned, strategic judgments which courts give deference. And I do want to point out one thing. I believe in the reply brief at page 4 indicates that trial counsel, that the people had said trial counsel was aware that Edwards had been kicked out, but there was no testimony about that. During the December 20th hearing at pages 15 and 16, it does appear that trial counsel did in fact say that he was aware that Timothy or TJ had been kicked out because he'd asked him, and he said that it was true. It's a little bit confusing with the testimony there, but my read on that is that's what that means. But I do encourage the court to take a look at those pages of the transcript, which are also cited in our brief. Now, moving on to the very last issue that I would like to address is the completeness argument, or the MRE 106 argument. This argument also fails. Many of the on-plate portions of the interview, including Edwards' self-serving denial that he was not kicked out, again, was hearsay. That's a self-serving, out-of-court statement. The trial court judge even indicated that if there'd been an objection to that he would, it was his self-serving statement, I would have kept it out. So likely a futile motion. But also, if you look at the record, it indicates that trial counsel engaged with the prosecutor prior to trial in a very reasoned and trading of senses, where they compromised on what would and would not come into the court, what would and would not be played for the jury. This is an inherently reasonable thing to do. Trial counsel kept out some of the most damaging statements that were in that interview, including Trooper Vance asking questions about uncharged child abuse allegations, some vouching for other witnesses saying they're saying the same thing. Why aren't you saying this? As well as Trooper Vance implying that Mr. Edwards is being less than truthful, which is also a potentially damaging thing to present to the jury. But I also would like to point out again, unfortunately not binding on this court, I wish it were, but People versus Rogers, which is a procurement opinion of this court, issued March 31st of this year. So after briefs had been filed, docket number 367414, page 4. And Judge, I'm sorry, Karabukin. Karabukin, I'm sorry, I apologize. You did dissent in that one, but the key point about that
But not on this issue.
This issue, you agreed with the majority that it is inherently reasonable for counsel to compromise. So based on the totality of what occurred here, the people's position is that Mr. Edwards has failed both prongs of the Strickland analysis, and the people would ask that this court affirm both his convictions and sentence. And pending the court's questions, I would rely the remainder of my time on my brief. Thank you.
Thank you. This is going to have to be brief, Mr. Foster, as you used up most of your time during
Oh,
your.
okay.
Yeah, so-
It will be brief. Thank you.
Okay, go ahead.
Brother counsel says it's okay to compromise. Trial counsel compromised his client's defense. That is not okay. You don't compromise when you have strong evidence that you can bring in and just for the sake of agreement and not going in front of the judge to argue strongly for your client's defense that this critical evidence should come in. So I strongly disagree that compromise was any sort of defense and sort of reasonable strategy. Let the judge make the decision. In terms of the motive for fabricate, that goes to lack of investigation. There wasn't a follow-up, an extensive interview. They just blew it off from the beginning. So under Trachtenberg, that needs to be, that's a strong reason to remand for a new trial. And even though the judge may have said, well, we don't have enough foundation for some of this character evidence, I believe the foundation is very minimal and there was sufficient foundation. And there's no requirement that there's a community standard or something. Reputation is a very general term, and it could have been admitted, and it should have been admitted through multiple witnesses that have seen TJ with children, and they trusted TJ to be with their own children even after the conviction. So with that, unless there's any further questions, I'd ask the court to remand for a new trial.
Okay, I don't believe so. Thank you very much.
Thank you.
These will be submitted. Long way to go. All right, that brings us to item 4, docket number 369801, People versus Aaron James Nowicki.
Good morning, Your Honors. Melissa Krauskopf on behalf of Mr. Nowicki, who is the appellant in this matter. I think the issues that I raised in my brief were pretty clear cut. I certainly don't want to repeat what I've already put in my brief to this court. So I'm happy to rest on it at this point in time and take any questions that the court may have for me.
Well, would you be prepared to address an issue in the standard 4 brief, which was the entrapment issue? Or is that not something you're able to get at today?
Probably not off the top of my head today, Your Honor, not on Mr. Nowicki's. I know Mr. Nowicki filed a standard 4 brief. It was lengthy. I recall having to file a motion to have it accepted because it exceeded the page limit. So that I don't think I'm prepared.
Well, maybe what we could do is we could have opposing counsel address it, and then if you had anything to say on rebuttal, you know.
Yes, Your Honor. Does the court have any other questions for me?
No, I think Judge Krabkin's brought up the issue we're interested in.
Thank you.
Morning, Your Honors. Monica Wilson, Assistant Attorney General on behalf of the people. Judge Korobkin, I will go dive directly into your question first. I believe that issue was not raised at the trial court, so it is unpreserved.
Well, it's right. It's an ineffective, it's sort of coming in through the ineffective assistance claim. But I think, if trial counsel was ineffective for not raising an entrapment defense that would have been successful, that's a legitimate issue to be raised.
Correct. And at this point, believe that issue is pending on these so-called ghost cases. That is, I believe at this point, pending at the Michigan.
Yes, it's one of the
Supreme Court.
ghost cases. Yes.
So yes, so I guess I don't think he can meet his burden just based on the record before us that he was entrapped. So I think he would fall on those grounds.
Based on the current published J case from our court, right?
Correct.
Yeah, okay.
Yes. And
There is one, it does seem there's one difference, well, there might be more than one, but one difference I can think of between even the current published Court of Appeals Jade decision and this one is the clarity with which the decoy expressed their fictional age. And I think, that was brought in through a sufficiency of the evidence claim on the counsel brief, but in the standard 4 brief, the argument seems to be that, well, sort of in addition to whatever sufficiency issues there are, doesn't that speak to entrapment when the decoy is very, very vague, kind of vaguely alludes to a possible age situation, when in fact that was not what the defendant brought up, during the conversation.
And I guess that goes into my argument as to issue 1, as to Sister Counsel's brief, her sufficiency argument that was raised on appeal, that a lot of this case turns on this 15 message and what that meant. And I believe in this case, which we don't always have, is Mr. Nowicki himself testified. And so what was put in front of the jury was his own testimony, which isn't necessarily consistent with an entrapment defense, because at one point he said, I just didn't see the message. And I don't think that would be consistent with an entrapment defense. He also said at one point, I believe, well, I didn't see it, but if I did, it wouldn't have made a difference. And again, that is not consistent with an entrapment defense. At one point, I believe if I remember correctly, he even claimed my phone was hacked. And I believe the officers were like, if your phone was hacked, why are you here? Because you wouldn't have known where to arrive if somebody else was on your phone and
But
not you.
why is a defendant's testimony ever relevant to an entrapment defense? I mean, isn't the premise of the entrapment defense is, the person meets all of the elements, all the elements of culpability were met, but it was something that in the way that the investigation went about, that was the problem. So I guess I'm curious, I'm not sure why we would care that much about what the defendant himself said if we're looking at the entrapment issue.
Well, I guess if he's saying that he was, apologize, I can't think of the exact words, if he was led into committing criminal activity that he wouldn't otherwise have committed, I think his own testimony would substantiate that he was intent on committing this activity regardless. And so I think the issue is adequately covered by counsel's sufficiency argument. I said, I don't think adding an ineffective for sufficiency claims would add to that, because his defense was entrapment is saying, well, they tricked me into not seeing this, but on counsel's argument of sufficiency, it was, I didn't see it, but if I did, it wouldn't have mattered. So if he's saying even if I had seen the 15, it wouldn't have mattered. I don't see then.
Counsel's argument was actual innocence, and
Yes.
the entrapment defense would have been, accepting culpability, but then having a defense of entrapment.
Correct.
But wouldn't that also feed into the ineffective assistance of counsel claim that there should have been a entrapment defense that was raised because of the circumstances of the case?
And I think when it comes to ineffective, and I think trial counsel has to decide as a matter of strategy, if you're talking about multiple optional defenses here, can I go with this one, or this one? It's just a matter of trial strategy for trial counsel to say, this is a stronger argument. Because I guess technically you can raise both. I mean, I spent a long time as defense counsel, and it wasn't me or it was self-defense. Technically, yes, you could raise both of them, but
This is brought up before trial, right?
yes.
Yeah.
And so I think but trial counsel may have just said, I think actual innocence is a better defense. And without the benefit of the Ginter hearing, to hear from either Nowicki and or trial counsel as to why he chose this defense. I don't think on the record in front of us, which is what we're bound by when there's no Ginter hearing held, I don't think this court can say it wasn't a matter of trial strategy to pursue actual innocence versus entrapment. Because again, you can raise both, but probably an ineffective claim in there too, if you to say, well, it wasn't me, but if it was entrapment. So I think trial counsel is a reasonable strategy to pick one over the other.
I mean, I thought the jury would never hear about an entrapment defense. We actually talked about this a little bit in case number one, but
Yeah.
typically I think once the entrapment defense is ruled on, it just doesn't come up in the rest of the trial, I think.
Correct.
Okay.
So, but I think trial counsel just went with what he thought was the better strategy of actual innocence versus entrapment. And I would just also note very briefly, as I do in many of these cases, I did check Otis this morning. The second issue raised in sister counsel's brief is about OV 19. He was paroled in April of 2025. Looks like a couple weeks after these briefs were filed. So I would say that the sentencing issue at this point is moot.
Is he still on parole?
Yes, he is still paroled until April of 2027.
And if OV 19 was not scored, that would have brought him down to a potential non-incarceration sentence.
I believe it would have put him into a straddle cell, if I can think
Right?
off the top
Like
of my head.
zero to something.
Yes.
Right? Yeah. And so if the trial court had decided not to incarcerate, there would be no parole, right?
He would be on probation, not parole.
Not parole.
Yes. And if he violates probation, then he gets a new sentencing hearing. But if you violate parole, so it may not be moot if he
Doesn't
was on
sound completely
probation.
moot. It sounds kind of close, but
But if
maybe
he's- if
maybe
he's
not
on-
totally there.
If he's on parole and you violate probation, you get a whole new sentencing hearing. You violate parole and you have a parole hearing, which I don't think your guidelines are relevant like they are to a resentencing hearing. So, because if the idea was we'd be reducing his minimum sentence to get him paroled earlier, he's already been paroled. So there's no effective relief I don't think that this court could give him. And other than that, Your Honors, I would rely on the briefs that were filed. Thank you.
If I may just briefly respond to the sentencing argument. I don't think that the OV-19 issue is moot because Mr. Nowicki is still on parole. If we remove those points, it actually drops his guidelines down into an intermediate sanction cell. And so a prison sentence really would not have been on the table at all. And so I think because he is still on parole, is on parole for at least another year, and then who knows what happens after that. And as counsel pointed out, actually, you are entitled to more protections on a charge of a probation violation than you are on a parole violation. I don't think the sentencing issue is moot, so I would ask that the court still consider that.
And I think the restraints associated with parole are different from the restraints there. So it's not identical. So
That's correct, Your
you'd be
Honor.
talking about a different set of restraints on his ongoing liberty, I think. So.
Yes, Your Honor. And other than that, I don't have anything to add unless the court has any further questions of me.
Thank you.
Thank you.
That case will be submitted. Item number 5, docket number 367476, People versus Henry Louis Jones Jr.
Morning, Your Honors. Michael Throne on behalf of Mr. Jones. Mr. Jones, of course, was convicted of first-degree felony murder, first-degree child abuse. He was sentenced to life without parole on the murder count. The parties missed a juvenile lifer hearing. Should have occurred under Parks, and that did occur. This court actually went back to the circuit court. The court granted that motion, and on behalf of Mr. Jones, I thank the court for being patient while that proceeding worked its way through, and Mr. Jones did end up with a term of year sentence. So we appreciate the court's patience on that. Regarding issue 1, that's an issue that I've tried to be thorough in the brief. I don't really have anything to add to the brief. It's probably the paramount issue in this appeal. Unless the court has questions for me, though, I think I'd be inclined to stand on it. I don't want to repeat what's in there. I tried to be thorough. Issue 2, of course, is a change in law argument. We've acknowledged in our brief that under existing law, Mr. Jones has to lose on issue 2 if the court reaches issue 2. I haven't asked for a conflicts panel or anything of that sort, although the precedent that Mr. Jones bumps up against on issue 2 is from this court. It's not from the Michigan Supreme Court. I did raise it in the event that Mr. Jones is in a position where he may want to continue the appeal, but we do lose under existing law. Issue 3, of course, is the sentencing issue. Unless the court has any questions about me on any of the issues, I think I'd be inclined to stand on the written brief.
I have a question on issue 3. What is sufficient? What is expected of the trial court to consider youth as a mitigating factor? Because on this record, the judge definitely acknowledged the youth and acknowledged that the report, et cetera, but didn't do anything further and made its record. And I understand that no magic words were used and we don't require magic words, but what does the court need to do in addition to just acknowledging the youth and the relevant law that says that it's
right? No, I understand and I actually, I would have some sympathy for trial courts because there are no magic words. That's what the case law says. I think, I look at it, I think it's almost to some degree, it's not a proportionality argument because we talk about Boykins and there's other things. It's not literally a proportionality, but it is similar to that where the defense is arguing, in this case, the trial judge did begin her remarks by stating, I understand about the brain science and she acknowledges youth. She did do that. But the thing we're arguing is, then when we continue on through the comments of the trial court, the case law says that a lot of these factors, Miller factors, the court is actually required to look at them in a way that isn't neutral, but rather to look at them in a way that through the lens of the client's, of the defendant's youth. And so, when we look at the remarks that this judge made at this hearing, did the court do that? For example, probably the biggest problem that the defense had in this case was Mr. Jones he did have misconduct tickets in prison. He didn't have the greatest record after, he was sentenced. And, the judge did focus on that and talked about how he, actually she rejected his excuse for that was that, well, the victim's family was in the prison and this sort of thing. And she said, well, that would mean more to me if he wasn't violent before and he didn't, continue to be violent. And so I think what the defense is arguing today is, he was 18, 19, he's going into prison for the first time. He's there with adult offenders. Don't we mitigate that somewhat and say, is it really that unusual? It's not unusual. We know it's not unusual for an 18, 19, young, anybody really goes into prison for the first time to have to sometimes prove themselves against other people who are in there more experienced. And so he picked up some misconduct tickets. Do we put that much weight on it? And given his age, don't we maybe put less weight on the fact that he had some misconduct tickets involving other, inmates, not really involving conduct that, would be more planned and thought out, but I think fighting, so conduct that is like Miller talks about the conduct of youth, impetuous or impulsive and that sort of thing. So I think that's the argument on issue 3. I agree. There's no magic words. I have some sympathy for the trial court, but I think, our argument in this case is she just respectfully didn't put sufficient weight on defendant's youth when she went through the factors.
Just take it one step further. If Boykin says that trial courts are to consider the defendant's youth and must treat it as a mitigating factor, in your experience or opinion, does that mean that they therefore must mitigate the sentence, or can the aggravating factors outweigh that such that it's still not less than mitigated?
No, the way I've interpreted Boykin is that when the judge looks at the facts in the case, he or she has to do it through the lens of just acknowledge the defendant's youth. So no, I'm not saying that the judge has to reach any particular outcome. I think the court, is allowed to look at misconduct tickets in prison, is allowed to say that they weigh against a lenient sentence. But all the appellate courts ever have, whenever they're looking at a sentencing, is the trial judge's comments at sentencing. And I think we have to be able to look at those remarks and say that when the judge was evaluating whatever is in front of the court here, misconduct tickets, they were had in the back of their mind, or that they were dealing with they were addressing a defendant who was a youth. And so maybe we look at that differently. We do look at that differently than if, someone is 40 years old, has been out of prison, before, and they're committing misconduct tickets. They know the rules, they know. And I think that's how I interpret Boykins. I don't know if that answers the court's question or not, but.
I think it does.
Oh, okay.
Thank you.
Okay. All right. Okay. That's all I have, unless the court has anything else. Thank you.
Good morning, Your Honors. May it please the court. Elizabeth Matthews on behalf of the people. I really don't have anything else to add, so I'll rest on my brief unless there's any questions Your Honors may have of me. All right. Thank you very much.
In that case will be, there's nothing to rebut there, is there? Okay. And this is the item 6, docket 372-637, People versus Sherry Lee Lillis. And we have a remote argument from Ms. Malthosian.
Good morning. Can the court hear me?
Yes.
Thank you. I'm Janice Dager Margosian, Your Honors. I'm here on behalf of Ms. Lillis. As a preliminary matter, I'd like to say that also I put in my brief in a footnote, she is off probation. I put in my footnote also that there may be an issue still because this is a matter of public significance. That would be why we continued the appeal. Other than that, I'm going to rest on my brief at this time and save time for rebuttal as needed.
Okay.
Good morning, Your Honors. Tom Ginster on behalf of the people from Montcalm County. The issue before the court, of course, is whether the court is a condition of probation and tell a probationer they can't have contact with their spouse, his or her spouse. And earlier this week, the Michigan Supreme Court on Monday issued the decision in People versus Hess, which ironically arose from our county. There they cited and quoted with approval the case of People versus Graber, 128, Mishap 185. In that case, which was decided by a panel of this court 43 years ago, it had very similar issues. There, the defendant was also alleging that the condition that the court's condition that a probationer not have contact with their spouse impermissibly burdened his constitutional right to marital privacy. And it was cited, maybe indicted by Hess Court as an example that this can be lawful if it's rationally related to someone's rehabilitation. So the court knows the chronology.
I mean, that was a case where the spouse was frightened of the defendant because there had been some domestic issues, right?
Exactly.
So the condition was kind of there to protect the spouse from the potential violence, right?
Yep. Absolutely, Your Honor. In Graber, the condition was imposed midstream when the spouse contacted the probation officer and said, Mr. Graber is harassing me, right? So it is factually different, but the underlying principle I would suggest remains the same, that it can be a lawful condition of probation if it's rationally related to the potential for rehabilitation. So the defendant presented.
So I'll just be honest. I don't take any issue with the outcome in the Graber case, but we were doing some research about how a lot of other states and jurisdictions do this kind of thing. And they allow these types of restrictions, but they do a couple of things. They tend to do a couple of things in the analysis. One is they impose some sort of special scrutiny, closer look, carefully considered, that kind of thing. And the other thing is they tend to require some sort of tailoring, whether it's narrow tailoring or avoid overbroad restrictions, a little bit more. In other words, they have a little bit more of a close examination around the relationship between the means and the ends than we might have for a restriction that doesn't involve that doesn't implicate constitutional rights, like, you know, no drinking alcohol or whatever. And so that we may get to the same place here, but it does seem like most jurisdictions at least recognize that something like restricting contact with your spouse is subject to something a little bit more searching than just your average probation condition.
Yeah, we could, the people would welcome to apply that standard to this case. And I would suggest that it would still not change the lawfulness of the condition. Initially, the defendant presented herself on 2 November 2023 for sentencing. She was already on probation out of Kent County for possession of methamphetamine and retail fraud. She had a very trenchant, a 6-year substance abuse issue with methamphetamine, cocaine, you name it, opiates, alcohol. So Judge Krieger sentenced her to a concurrent 3-year term of probation. She also imposed 60 days of tether. And from that until she was finally violated, her third violation over the next 5 months, it was a pretty challenging time for Agent Chapin to supervise her. She only made it about a month. She tested positive on December 5th. She was positive for methamphetamine. She pled guilty on the 22nd day of February to multiple tether violations. It was traced back to her husband, Mr. Beamer, who was a convicted felon and admitted methamphetamine user. He falsely represented to the court that he'd been clean for a year when he was just released from probation from parole 5 months earlier. He had an extensive criminal history. So there was as the court is aware, this is a standard order of probation just about in every case that you can't associate with a felon. And so here the court did accommodate her. It wasn't a case where the court right away said, hey, this is a scam, this whole marriage is a scam. You're just trying to avoid you're a frequent flyer in the criminal justice system. And I'm just disregarding this marriage because I know you're just scamming the court to avoid the standard condition of probation. You can't hang out with a convicted felon. She didn't do that.
No, she was very patient and concerned about the situation.
Absolutely. Yep.
Can we fast forward to the I think it was in May when the actual the sanction that's at issue was sort of the way I see it, there were kind of three steps here. First was, hey, by the way, I'm married to someone who's a felon, and the trial judge brings him up and says, okay, after all of this, I won't impose this restriction. Second was, I think what you were just talking about, February, where there were some issues. And I think we ended up with a situation where it was, you can have some contact with him, but only, going to legitimate appointments and on the phone. That was and then we get to the last straw, so to speak, where she's essentially violated and sentenced to jail. I had a little bit of trouble figuring out what happened at that last thing, because it seems like instead of occurring before the trial court, in this case, they went to the Adult Recovery Court, the ARC. Can you tell me a little bit about how that works and what there wasn't like a hearing right before the trial judge about this issue. It was more like we heard that the ARC said, okay, no more contact with your husband. And then we don't have a lot of details.
Yeah, part of the requirements of the ARC was that she was to attend outpatient AA groups or NA groups. She didn't have a license. Mr. Beamer did have a license. So the probation agent, with her agreement, she assented to this on the record. She said, okay, he can drive you to appointments. And just about in every appointment, he was taking her somewhere else. And then she presented forged AA or NA slips. And at that point, they amended the probation to say that you shouldn't have any contact. And so the last one, it was portrayed in the defendant's, my sister.
That amendment was by a probation officer, by a judge, a different judge? I'm not,
no,
it's a little unclear how this ARC works.
It was Agent Chapin who oversaw the ARC program. So she was still in that program. She had 27 calls since March, or since the defendant's or Mr. Beamer's arrest on March 22nd. And then he's calling her from the jail. He's circumventing the court's order by calling somebody else and then having them do a three-way call with the defendant. So that's my understanding of what happened in this case. It wasn't just one phone call. It was repeated phone calls. At one point, just like in the facts of Graber, she expressed relief that he was out of her life. She had 3 children, and that she attributed all of her failure to her relationship with Mr. Beamer. So, Your Honors, as you know, not often does the legislature, it'd be a lot easier job in this court if they expressly said what their intent was. In the probation statute, the legislature actually said in section 771.41, it says it is the intent of the legislature that the granting of probation is a matter of grace requiring the consent of the probationer to its granting and continuance. And again, so at every stage of the proceeding, when she violated it and they had to amend the probation, she agreed orally and in writing to the amended orders of probation. Now, we can think in terms of other contexts. You give up your gun rights for maybe 100 years in this state. If you're on probation or parole, you give up your right to challenge your Fourth Amendment rights to privacy. So in other contexts, there's other constitutional issues that are routinely waived as a condition of probation. And she agreed to this. She got the benefit of the bargain, and it wasn't until
I'm sorry, I'm sorry to interrupt you again, but I understand she agreed in February you can only go to legitimate appointments with your husband and phone contact. That the record
Right.
seems to indicate that was like everyone's agreement about that. I don't know that the record reflects that she agreed to the further tightening of the restriction, which essentially became no contact at all. And I take it that is what she's challenging in this case.
Yeah, I really can't speak to that. I think that was in the discretion of the agent. But the point is, as engraver, she made no challenge to the conditions initially. I mean, the whole tenor of it was, we're going to allow you to associate with your husband as long as things don't go sideways here, as long as he is continuing in his rehabilitation. And the court's judgment was vindicated when on 22nd March, now we're into, she's on probation for 4 months. Mr. Beamer ends up, deputies Todd Wenstra and Edwards are administering him Narcan in the Sheridan Shell gas station when he's passed out in his 2022 Dodge Ram truck with a pipe and cocaine, baggie of cocaine on the seat. And so even after he was arrested, she insisted of continuing to contact him. Wasn't a healthy relationship. She got kicked out of her mom's house after her release from Bear River. And so I think, again, I think it was an individualized, a graduated condition. It wasn't a blanket condition. I think the court respected her marital privacy rights. And I think that that's very important. I would concede that that's marital privacy is one of our cherished constitutional rights, but in this limit, under the limited facts of this case, I think it was appropriate and lawful. All right, thank you.
Thank you.
Any rebuttal?
Just very quickly, Your Honor, what I was just hearing in the last part of this argument is very much what went on in the trial court. If you look at the transcript at 11 and 12, the judge goes on and on and on about what a bad guy this husband is. And that's really that's not what this is about. All of that is extraneous to the question of, as Mr. Ginster just admitted, the right to marital privacy, and and as Judge Korobkin brought up, it would be reasonable to subject that condition to a different set of considerations. Probation is all too often what people know about the individual in the community, and these things are thrown around apart from the record. And I would just ask the court to consider that in making its decision. Thank you. I appreciate your time.
Thank you. We will submit that case. Item number 7, docket number 373627 is People versus Annette Perkins.
Good afternoon, Your Honors. Michael Ford on behalf of Ms. Perkins. I think last time I was here, I think it's the afternoon by now. Hope
It is.
So
by the time we're done today, somebody's going to be saying good evening.
yeah, it's been a long, I know it's been a long morning. The court has before it the original brief filed by original appellate counsel. I'm substitute appellate counsel. I did have a short window of time to file a supplemental brief. I didn't find any issues that previous counsel missed. And so you have his brief, and then you have standard 4 brief filed by Ms. Perkins. Similar to an earlier case you heard this morning, there's a question of, is the issue moot or not? Ms. Perkins did go before the parole board in September of 2025. She was not paroled. She's been continued. She's still in the Department of Corrections. And I guess my position would be that on the proportionality issue, I think there is a real mootness problem for the defense. I think the issues, I don't know what the remedy would be. However, OV4, that is an issue the court should still reach for a couple of reasons. One, it would be that I don't know what they do with it, but I mean, the Department of Corrections, the parole board, they still have the pre-sentence report. There's actually a case, published decision from this court, People v. Nepper, September 23rd, 2024. There's not a number on it yet. he said he didn't find a number. I think I just checked a few days ago. It seems like there should be 2024, but KNEPPER talks about that. So for that reason, I think the court, probably should still reach the OV4 issue. Her guidelines range would fall actually to an intermediate cell. They would go down to 10 to 29 months. So I would, unless the court has any questions, I'll stand on that. Okay, thank you.
Something else?
No, I jumped the gun. I'm sorry, I jumped the gun. I thought, I apologize. I jumped the gun. I thought, okay, you didn't have any questions.
Oh, I was just checking, but
We're
I
good.
thought you were going to make another.
No,
comment or something.
no, we're good.
Okay.
We're
Well, you
good.
have time for rebuttal.
No, we're good.
All right.
I appreciate it. Thank you.
Sure.
Thank you, Your Honors. May it please the court, Katie Jory on behalf of the people. Your Honors, I did reply to defendant's standard 4 brief, and otherwise I would just rely upon my brief unless there are any questions.
Thank you very much.
Thank you.
That case will be submitted. This brings us to our last case for the 10 o'clock call. It's item number 8, docket 374374, People versus Eugene David Medlin.
Good evening, and may it please the court, Jonathan Simon on behalf of Mr. Medlin. Mr. Medlin was charged with possession with an explosive device with intent, also a couple of counts of felonious assault. But at the preliminary examination, an added count was made involving a vehicle which was at the facility. There was some damage to the vehicle. And the witness as to that vehicle was a Mr. Ortiz. And maybe about a week or so before trial, Mr. Ortiz notified the prosecution he was undergoing emergency gallbladder surgery, removal, I guess. And there's also, I think, a letter from his doctor. But Mr. Ortiz intended to, I guess, tough it out. He was intended to appear, but he did not appear. And the court found that he was unavailable. And we believe that there was not a sufficient finding to establish the sufficient evidence to establish the finding of unavailability. There was no attempt made that day to locate Mr. Ortiz or his doctor to find out his condition. Apparently, he had indicated he wasn't feeling particularly well. I guess some nausea or something, perhaps a side effect from the surgery or the medication. But in any event, the finding was made, and the testimony from the preliminary examination was admitted. The testimony was in support of this added count from the preliminary examination. Now, a preliminary examination, of course, takes place very early in the proceedings, weeks into the charge, and very soon after counsel comes on board, very soon after counsel obtains discovery. And there was, and of course, preliminary examination is only a probable cause finding. There's no confrontation rights. And so the inquiry is very limited. And because of that, there was not a whole lot of examination of the witness. And I don't think that there was any much of the way of cross-examination. And the charge was added. And of course, based upon that testimony, the conviction was accrued at the time of trial. And we believe that the court should not have found that he was unavailable, that the court should not have allowed that testimony, and that count should not have been allowed to proceed to verdict, which resulted in another conviction. Now, certainly it wasn't his most largest exposure. The 180-month sentence for the count 1 was more time than any of the other counts, but it did create another conviction. It did create additional language and information in the pre-sentence report. Certainly, there is a right to be sentenced based upon accurate information. And even though it may not change the guidelines under and require sentencing under Francisco, I think the conviction should be overturned. And because the conviction and the sentences were based upon what would now be inaccurate information, there should be under, I think, Townsend versus Burke and other courts decisions indicating that there must be a sentence based upon accurate information, that there should also be a resentencing. Count two talks about the I'm sorry, not count two. Argument two talks about the proportionality of that count one sentencing. And it kind of ties in now to argument one, because again, the sentence for the count of the added count, Mr. Ortiz's vehicle, was, I think, something which influenced the court in terms of its decision to impose a 180-month minimum sentence. And so I believe that it also affects the proportionality of that sentence as well. So for reasons stated in arguments one and two, we ask the court to vacate count six and to remand for resentencing.
Any questions? No. We have time for rebuttal, but I don't see anyone. Oh, there we go. All right, go right ahead.
Thank you. Taya Duso, Midland County Prosecutor's Office, on behalf of the people. I will largely rest on the brief that we have submitted. I think it addresses both issues. However, just to address some of the points that were made by Mr. Simon, as to the first argument regarding the witness who was unavailable for trial, factually, the witness had indicated and provided a doctor's note to the people, which was brought to court and presented for the judge's consideration, indicating that he did have emergency gallbladder surgery the week prior to trial. Our office did contact him on the first day of trial to see how he was doing. The doctor's letter actually opined that he should not come to court, that he should not be involved in this, both, I think, based on his physical situation, as well as the fact that he was on opioids, which typically we don't want people testifying when they're under the influence of things like that. And so we made contact with him the first day of trial to just sort of assess what his plan was, not knowing how his recovery was going. And at that point, he had indicated that he wanted to participate in the proceedings, but there was still the issue of his health. And he had indicated then to us that he was having some, he'd been throwing up all day, having some digestive issues, and, result of the surgery probably. But at that point, he had indicated he was intending to go seek further medical treatment. And no, we did not hear from him on the second day of trial. However, based on all the information we had, I think the court's ruling on that issue was sound, that, we had documented evidence, we had a doctor's note, these things that naturally flowed from a surgery were occurring. And, at that point, I think it falls squarely within what the definition of unavailable can be. So I think the court made a valid finding there, and that then allows for the preliminary exam transcript to be admitted as the prior statement, and as the defense attorney had an opportunity at the preliminary exam to question him about that count. And quite frankly, as you go through a preliminary exam, sometimes evidence comes out that nobody is really aware of. For example, in a criminal sexual conduct case, you may have a victim bring up another incident that nobody was aware of. And at that point, then, the defense attorney still has an opportunity to cross-examine that witness on that. And in this case, we're even a bit better situated, because at the very outset of the preliminary exam, and prior to even coming into the courtroom, the prosecutor had indicated to the defense attorney that this is my intention, I'm going to add this charge. The defense attorney had all the information that was relevant to that charge already, and then, ultimately had warning before the exam even began. If he had questions, if he wanted to cross-examine him, he did have an opportunity to do so. And I think there was also an argument.
Can I ask about, I'm sorry to interrupt. Can I ask about that? I mean, it seems a little bit, the standard at the preliminary exam, right, is probable cause. And so it's interesting that we say that you had a prior opportunity to cross-examine when we know the standard is so much lower. And it seems to me that what this means is if you're a defense counsel and you're doing a preliminary exam and you know there's probable cause, you just know there's probable cause, you still have to try to do a rigorous cross-examination of all of the witnesses just in case they become unavailable at the trial, which is just an odd set of incentives to have. I don't know if you can speak to this, whether this is very common that we admit preliminary exam testimony at trial for unavailable witnesses, but the idea that he had an opportunity to cross-examine, yes, of course he had an opportunity, but the incentives and motives were obviously going to be different at the preliminary exam.
So I would say that this situation is common, as I had indicated in many preliminary exams, there are counts added, and whether that is something that is known going into the exam or something that sort of evolves as a course of the testimony that it comes out during the exam, this does happen. And then as far as admitting the testimony or the transcripts, I mean, that just falls squarely within the rule of evidence that allows for that to be admitted as long as and it comports then with the confrontation issue, because there was that opportunity for cross-examination. And really, if you think about it, the jury trial standard is the highest, right? Beyond a reasonable doubt. At no other hearing, at no other point in a case is a defense attorney going to have that exact same incentive to cross-examine. And so, if we want to make a rule that says, well, we have to have the exact same incentive, there really never would be a true opportunity for the exact same level of incentive for cross-examination as there is in a jury trial. In going to the second issue, as far as the sentencing goes, I think a bit of an interesting argument that I didn't quite pick up from the brief, which is that, part of the reason for resentencing should be that, this count 8 that is in contention in issue 1, if that was reversed, then the sentencing would have been based on inaccurate information. But truly, if you look at the sentence, the argument here was about the sentence for count 1, which was the highest count, the one that he received the 180 months on. And as defense counsel put in his brief, basically the court's entire rationale and entire statement in regards to the sentencing, that count really wasn't taken into account. The court was more concerned about the conduct in this case and the extreme level of danger and potential, destruction and loss of life that could have happened, had this situation gone differently. And a lot of emphasis is placed on the idea that, he's got mental health history, he's got substance abuse history, and, quite frankly, while I can sympathize with some of those things, I don't know of any controlling case law that says automatically those are mitigating factors that need to make the sentence be at the bottom of the guidelines. Quite frankly, this sentence wasn't even at the top of the guidelines. It was close, but it still left some room there. And I think it was appropriate when you have multiple law enforcement individuals out there that could have, quite frankly, been killed. And by the defendant's own admission, he was trying to commit suicide by cop and didn't really seem like he was hesitant about taking them with him. And I think that's where the court was coming from in the rationale for the sentencing. And because the sentence is within the guidelines, I think that's totally appropriate for the court to use that as its rationale for where it landed within the range. The court, some of the argument I think almost sounds like, well, why, the court was using things that were already contemplated in the sentencing guidelines. And yes, it was, but it didn't have to articulate anything else because the sentence wasn't outside of the guidelines. So just simply to articulate why it chose the number it chose within the guidelines, I think all the arguments that the court made were perfectly appropriate and accurate. I don't think that there's a disproportionate situation here, given the extreme amount of risk, the planning, the plotting that went into this, and the just total disregard for the loss of life that could have happened had he lit. I mean, he was found with a lighter in his pocket. He could have lit that and everybody would have gone up. So that's where the court was coming from, I think, with the rationale for the number that it chose. But again, being within guidelines, the court wasn't required to do anything different. So I would ask that the sentence be allowed to stand as it was.
All right, thank you. Any rebuttal?
Well, I agree that some of that proportionality argument did not include the factors involved with the added count. But I think that it merits consideration by this court. And I believe that for the reasons stated in both of those arguments, that the count should not have been added, or the count should not have been allowed to proceed to jury verdict, and that there should be a resentencing as to all counts.
All right. Thank you both very much. That case will be submitted, and we're going to take a recess for a bit and come back out and start in on the 11 o'clock call.
The Honorable Court of Appeals of the State of Michigan is now in session. Please be seated.
All right. Good afternoon. We're going to carry on here and take up where we left off. The next case is item number 9, docket number 375-823, Jeffrey M. Short versus Michigan State Police.
Good afternoon. May it please the court. Assistant Attorney General Adam DeBear appearing on behalf of the Michigan State Police. Now, this court should rule in MSP's favor for 3 reasons, but it should also reject plaintiff's reliance on the unpublished opinion in Chiravuri versus University of Michigan for several additional reasons. First, beginning with MSP's arguments, this court's cases recognize that a claim for personal injuries isn't simply limited to something for bodily harm, but it can involve an invasion of an individual's civil rights or personal rights. Second, this state's courts and federal courts both treat civil rights claims such as this as personal injury claims for purposes of statute of limitations. So I would submit that it would be incongruous to treat this as a personal injury claim for statute of limitations, but treat it as not a personal injury claim for the notice provisions. Third, when the legislature wants to require bodily harm for a given statutory scheme, it knows how to do so. This court just looks to the Governmental Tort Liability Act. There's 4 separate sections, exceptions to governmental immunity, that require a showing of bodily harm. So if it wanted to do that in the Court of Claims Act, it could have, but it didn't, and I would submit that's significant. Turning to plaintiff's reliance on Chiravuri, there's several reasons why this court should reject that reliance. First, the opinion in Chiravuri misunderstands the Supreme Court's holding in Christie versus Wayne State University. The Supreme Court didn't hold that the only exception to the 1-year rule is our claims for WICA. It was that WICA was the only exceptions to filing notice in the first place. Second, Chiravuri didn't arrive at its conclusion by employing the proper means of statutory construction, nor did it do so when relying on binding published opinions. I would submit instead of Chiravuri that this court rely on Genuine Counseling Solutions Center versus Governor, which I believe Judge Kelly was on that panel a few years ago. And that panel did, I would submit, employ the proper means of statutory construction. Third, Chiravuri relied on the definition of personal injury in MCL 600-6301, even though the legislature explicitly limited that definition to Chapter 63, and that the legislature chose to limit that definition to Chapter 63, which includes things like collateral source payments, structured settlements, annuity contracts. It makes sense that they limited those to bodily injury claims in that chapter, but not necessarily in other chapters. And fourth, and finally, Chiravuri improperly focused on the presence of a physical harm, which is a component of damages, but it's distinct from the claim itself. What it should have done is focused on the essence of the claim as opposed to the damages that form the component of the claim. In short, because plaintiff failed to comply with the Court of Claims Act's notice and verification requirements timely, MSP retains its immunity from suit. And I'll do my best to be brief, but I do think there's a handful of cases. We cited a lot in our briefs, but I think it's just worthwhile to address some of those cases and what they held. First, I'd start out.
But these are all in the brief?
They are all in our brief. First, Alfieri versus Bertarelli, which is a 2012 case where this court held that for purposes of MCL 600-2959, which is the comparative fault statute, that personal injury is not limited to claims for bodily harm. And in fact, it noted that today the statute of limitations for injuries to persons or property, which is MCL 600-5805, applies to several causes of action that rarely or never involve physical injury. And I think it's also important to note the statutory right at stake here. It's found in the Persons with Disabilities Civil Rights Act, specifically in MCL 37-1102. And it's that the opportunity to obtain employment, housing, and other real estate and full and equal utilization of public accommodations, services, and educational facilities without discrimination because of a disability is guaranteed by this act and is a civil right. Clearly, Trooper Short's suit here is an alleged violation of his civil right to be free from discrimination on the basis of a disability. That is a personal injury. It's an injury to his personal rights. I would point this court also to Russia versus MDOC, a 2014 opinion from this court, in which this court held explicitly that constitutional tort claims are subject to the 6-month notice requirement. And in Russia specifically, the nature of that claim was that the MDOC's policies prevented the plaintiff from receiving the treatment that he needed in the prison, right? It wasn't some sort of a car crash, or it wasn't something that involved a physical injury. It was the conditions of the prison that caused his allegedly conditions to deteriorate. And it's quite similar to the allegations that Trooper Short brings in his complaint, where the MSP's employment actions taken against him caused his PTSD to exacerbate and worsen over time. So it's a similar government decision results in a physical reaction to a body. It's not a bodily injury, but there is essentially a claim for invasion of personal rights, both in Russia, and in the claims that Trooper Short brings. Similarly, and we don't need to get into the subject matter of the case, but Mays versus Snyder, a 2018 opinion from this court, predominantly constitutional tort claims arising from government decision-making. This court again found that there was no question that they were claims for personal injuries. And then just again, I mentioned it at the outset, but Genuine Counseling Solutions Center versus Whitmer. I said it in my opening, but the reason why this court in that case followed the proper means of statutory construction is it looked to the words, the language used by the legislature. It employed dictionary definitions, and it arrived at a definition. And I believe it relied on the Black's Law Dictionary definition in that case. When you compare Genuine Counseling Solutions Center with Chirivuri, what Chirivuri did was essentially look to the types of cases in which the 6-month notice period had been invoked. And if you look to those cases, they involve West versus DNR, which is a motor vehicle exception case, which requires a showing of bodily injury. They look to Chisholm versus State Police, which again is a motor vehicle case, which requires a showing of bodily injury. I can't remember the name of the other case. I think it was Pike versus Northern Michigan University, which again had a gross negligence component that was the focus, but the claims against the state in that case were under the public buildings exception to governmental immunity, which again requires a claim of bodily injury. So you can't, while also complying with the structure of statutory interpretation set forth by the Supreme Court, you can't just look to cases involving claims that require a showing of bodily injury and come to the conclusion that the text as used in that statute also means requiring bodily injury. So again, I would submit that Genuine Counseling Solutions Center is the appropriate manner in which this court should construe the statute. It's also post Christie. It's a 2024 opinion and just predates Chirivuri by 1 year. I would also point this court is in our
the one that Judge Kelly is on. Was that post Christie or pre Christie?
Post Christie.
It is. Okay.
And there's actually Judge Karopkin, there's not to call you out for all the unpublished cases that you've been a member of the panel of, but there's also Browerman versus the University of Michigan, where I believe you were on that panel as well. And in Browerman, there's not the same analysis. It's just, I don't think it was contested in the case itself that they were claims for personal injuries, but there were Elliott Larson claims in that case as well. And this court again treated those as claims for personal injuries, subject to the 6-month notice provision in the Court of Claims Act. And that was also a post Christie, the same year as Christie, but it was in December of 2023. Moving on to the states and federal courts that have essentially treated civil rights claims as claims for personal injuries.
Before you move on, just as a point of curiosity, is this coming up now because of Christie? Because previously these things just went to circuit court and no one used any of the Court of Claims Act provisions? Is that, or fewer people use the Court of Claims Act? I know there was like some.
Right. I think when you look at it from a legal perspective, obviously it was Christie was a statutory construction question, so it was technically like always the law, but it wasn't announced in the manner that it was. And so when Christie came out and the notice provisions probably all of a sudden had to be filed for sort of every civil rights claim, it caused a closer scrutiny on everything. And that's why I think it's helpful to focus on the statutes of limitations cases involving these claims, because again, there isn't a specific statute of limitation contained in ELCRA or in the PWD CRA. You have to go to Chapter 58 of the RJA, Section 5805, and you get the general 3-year statute of limitations for injuries to persons or property. And sort of every case that I've been able to locate that state or federal for similar claims, treats these as claims for personal injuries. And it would be an odd result that they are claims for personal injuries for purposes of statute of limitation, but not for the notice provision, which is a waiver of sovereign immunity and something that's supposed to be strictly construed. And again, those cases, they're in our brief. I won't go into the details, but it's Garg versus Macomb County Community Mental Health Services. It's a 2005 Michigan Supreme Court case. That was also sort of, again, in a dispositive order from the Supreme Court from 2023, McMillan versus City of Kalamazoo. The Supreme Court recognized that the statute of limitations also applies to PWD CRA claims, the 3-year statute. We've cited Slayton versus Michigan Host Inc. It's a 1985 Court of Appeals opinion, 144 Mishap 535. Again, back in 1985, again, certainly well before Christie, this court determined that the 3-year period of limitations for injuries to a person under Section 5805 is applicable to an employee alleging discrimination in employment practices. Moving to the federal courts, you have Stafford versus George Washington University, District of Columbia Circuit Court case. And essentially that court, the circuit court, held that a violation of Title VI of the Federal Civil Rights Act is an injury to the individual rights of a person. Not in our brief is Sutherland versus Hardaway Management Company, Inc. It is, the citation is 41 F3D 250. It's a Sixth Circuit case from 1994. And it looks at the Section 504 of the Rehabilitation Act, which is sort of a similar federal statute to the PWD CRA. And the Sixth Circuit back in 1994 said that Section 504 of the Rehabilitation Act confers a general remedy for injuries to personal rights. Again, just kind of going a little bit into further detail regarding Chiravuri. With respect to Christie's holding, the Chiravuri panel seemed to look at the holding of Chiravuri that the only exception contained in the notice provision is for WICA claims, meaning that perhaps not even the 6-month notice period applies to the remainder of claims. But all that Christie held was that the only exception to providing notice in the first place, whether it be 6 months or 1 year, is for claims brought under WICA, the wrongful imprisonment, the wrongful incarceration conviction act. So that's the only exception to filing notice in the first place. The panel also seemed to focus on the idea that only the 1-year notice provision was referenced in Chiravuri, but the simple fact is that the plaintiff, or sorry, not Chiravuri, but the plaintiff and Christie never filed a notice of intent. So it didn't matter if it was the 6-month or 1 year. And I would submit that there's nothing in Christie that is even even dicta, right? Because that issue wasn't before the court. It wasn't argued before the court. The court didn't need to reach it. But if there is anything in Christie that this court would find persuasive to suggest that the 1 year period applied over the 6 month period, then it has to be dicta because, again, it wasn't an issue brought to the court by the parties and there was no reason for the court to address it. Would also, with respect to Chiravuri, just note again that Chiravuri relied on section or chapter 63 of the RJA Act's definition of personal injury to mean bodily injury. But again, I just note that the legislature limited that definition to chapter 63 of the RJA, and the Supreme Court has instructed that when the legislature does that, it's not appropriate to incorporate that definition to another statutory provision. And again, I would end with Genuine Counseling Solutions Center versus Whitmer, where it is looking to the text of the statute and figuring out the meaning from the words used in that statute. And I suppose I jumped the gun a little bit, but just with respect to the COCA's text, if you look to what someone is supposed to file, they are supposed to file under section 64312 when it talks about what's required in filing a notice. The legislature instructs that a claimant must file, when they're filing a notice of a claim, a detailed statement of the nature of claim and of the items of damage. And I think that when you look only to bodily harm, you're looking at only the items of damage as opposed to the nature of the claim. Because certainly you can have, and I've litigated Elliott Larson cases in the past, where the precipitating event was a car crash, and it was about police practices in the city of Flint. You can have Elliott Larson cases that involve physical injuries, and you can have Elliott Larson cases that involve non-physical injuries, like or a lack of bodily harm, like in this case where the trooper Short is arguing that he was deprived of his civil rights because of MSP's employment actions, alleging that they were discriminatory in nature. And I would submit that it doesn't make sense to sort of ignore what the claim is, splice it up into how the claim is pled to determine whether you have a 6 month or a 1 year claim. Routinely, the federal courts and the state courts have all found claims for civil rights are personal injury claims, and this court should do the same here. So we would ask, if there's no other questions, that this court reverse the trial court's denial of MSP's motion for summary disposition and remand for an entry in MSP's favor.
This might sound a little bit funny, but you think there's any difference when you hear the phrase injuries to person, and then when you hear the phrase personal injury? I mean, I know, grammatically, it doesn't sound like it's different, but as a general matter, whenever we're talking about, people who have physical, like slip and fall accidents or even med mal cases, everyone uses the word personal injury. No, right. If you're a personal injury lawyer, you don't go around saying you're an injuries to person lawyer. You just don't.
Right.
And yet all of the, or at least I think most of the statutes that you're referring to talk about injuries to persons. And I mean, maybe there's no daylight between them, but I could at least understand why someone might look at the phrase personal injury and say, well, that doesn't apply to me because I'm bringing an Elliott Larson claim or a Persons with Disabilities Act claim. As opposed to if they were representing someone who was injured in an auto accident, they would definitely think, oh, personal injury, that's what I'm doing, that applies.
So I think you're right that the statutory language in 600-5805, the statute of limitations, general statutory section, and 6431 talk about injuries to persons. But even under injuries to persons, right, the federal courts and the state courts have all said they include these claims for non-physical injuries. They include violations of civil rights. I think that big picture injuries to persons or property is tort liability. It's a tort claim, and tort claims are subject to the 6 month notice period. But if I have a claim that sounds in contract, or if I have a claim that sounds in real property, Those aren't personal injury or property damage claims. Those are property actions that would be subject, if it's not against the state, right, to the 15-year statute of limitations, or probably the 6-year general contract statute of limitations. Again, the state has a 3-year statute of limitations for every claim in the Court of Claims Act. But again, yeah, the personal injuries and property damages is tort. So I would submit that all tort claims are properly under this section, because again, all tort claims are treated similarly under section or MCL 600-5805. But no, I appreciate the question, Judge Karopkin. If there's nothing else, again, we just ask that this court reverse. Thank you.
I have, Your Honors, I'm not endorsed for oral argument.
Would you want to come up to the podium and we'll state your appearance?
James K. Fett appearing on behalf of Jeffrey Short.
Anybody have any questions for Mr. Fett? I don't have any. I think it's set out in the brief pretty well, so.
Can I just respond to Judge Kropkin's last question?
Sure, I'll incorporate by reference my question.
You
And
stole my thunder.
And now I'll ask it of you.
You stole my thunder. Because I was going to say we're supposed to give these statutes the plain and ordinary meaning, the common meaning. So if a person has an employment discrimination case, are they going to call Lee Free? Are they going to call Sam? The common understanding is personal injury. It's bodily injury. It's someone who was hurt as a result of negligence. So that's my only point. Thank you for allowing me to respond. Thank you.
Rebuttal to that?
No.
Okay, all right. Thank you. That case will be submitted. Brings us to item 10, docket 371-937, Brianna Fry.
Sorry to interrupt, though, I
Oh.
would probably need a couple more tissues. I spilled some water.
Notebook floating over there, or are you okay? It's all right. All right, I'll call that again. Item 10, docket 371-937, Brianna Fry versus Michigan State Housing Development Authority.
Good
Good
afternoon.
afternoon.
My name is Jill Bauer. I'm here. I work at the Legal Services of South Central Michigan. I'm here on behalf of Brianna Fry, who's in the courtroom. And I know that we've briefed extensively, and I know that you've read all of it, but I did want to emphasize a few things. The first thing that I wanted the court to consider is the fact that MSHA's very purpose is to keep vulnerable people housed. And any gaps in the policy that lead to the unhousing of a vulnerable person that I think we provided ample evidence did nothing wrong, didn't break rules, didn't do anything to lose her housing. If a gap in the rules allows things to skew in the direction of her permanently losing that housing, then that's a problem. And in this particular case, the gap in the policy allows MSHA to evade review in the denial of a hearing. And given the stakes, which is a loss of potentially lifelong income-based housing, which could be retained, forever, because if she has no income, she pays no rent. The stakes are pretty high for her as an individual, and there were no safeguards in this case to address the fact that she didn't receive notice. The next point is that MSHA and the circuit court had a duty to engage in what was a pretty complex set of underlying facts in this case, and neither did so. And in fact, the circuit court just wholesale accepted MSHA's version of events that notice occurred in this case, but MSHA provided no evidence of that notice. They could have said it was mailed on such and such a date. We never received any mail back saying that wasn't delivered. They could have done all of these things, and all they, like from the very beginning of the case, they just very firmly doubled down on the assertion that this notice was mailed and it was received, but they basically said our records may indicate to us that this happened, but they never provided any detail. And
Well, and no court or administrative law judge ever determined that notice was given. right?
exactly.
I mean,
Yes, at a minimum, that issue should have been engaged by either the circuit court or by remand to an ALJ.
and which of those options do you think is the most consistent with administrative law here?
Well-
Again, not that, so there's there's sort of the primary question is whether termination of the assistance was legal. But then before you can get there, there's like, did your client have notice, or was notice appropriately provided? So that missing the deadline was not something that can, result in not having a hearing. And so on
Well-
that second question, who is supposed to be the decision maker about whether notice was provided?
Well, I think before an ALJ can weigh in on a case, the hearing has to be granted. And the ALJ can't make a decision to grant a hearing. So I think, ideally, I would love it if this court just remanded it and said that Ms. Fry should have an ALJ hearing. Because
And you don't think the ALJ can have a hearing on whether notice was given?
in spite of my gray hair, my tenure as a housing defense attorney is not lengthy, but in my short experience doing a lot of ALJ hearings.
They don't do that.
I don't think
Yeah,
they do
okay.
that. Yeah. So,
So then it's the circuit court.
yes.
Yeah.
Or I would say this court could say it was, I guess this court could order that the ALJ engage with the complexity of the underlying facts and make a determination whether the termination of this voucher was merited. I guess maybe that would be skipping a step at the circuit court, but I don't think it could be remanded to the ALJ just to address the notice issue. I don't think that's how they do it. The next thing that I wanted to point out to the court that I don't know if we did really do this explicitly in our brief is that we used the process that was available to us. And routinely, if a hearing notice is missed for whatever the request deadline is missed, we reach out to the legal department, we make an argument to them, and they routinely grant late hearings. So this time we first of all, it was very hard to figure out what had happened. I had to FOIA 3 times before I got any documents from 2022, which is when this happened. And then we had made tentative requests for appeal as early as April. But when they were not successful, we felt that we needed to build a robust case. And that's why we went through the FOIA process, collected all of the evidence, and submitted a robust request to the legal department. And I would say that the response that we received is a final order of a contested case because there were rights at stake. It's the kind of case where she's entitled to a hearing. So it's not whether she got a hearing in this case, it's whether this kind of case entitles someone to a hearing. And not only did the letter effectively cut off her opportunity to challenge the termination of her voucher, but I think there was a concession in that letter that the APA now governs this case. We're not going to engage in any more communication with you. You need to go to the courts under the APA. So I think that concession kind of eliminates Mishta's argument about whether jurisdiction was proper. And then I sort of touched on this, but it's hard for us to prove the omission, but it could have been very easy for Mishta to prove that omission never happened by just giving us the details of their records that they relied on to say that this notice was received. And I guess this isn't necessarily a legal argument, but why would Miss Fry, who had always, we showed, been very attentive to turning in paperwork and and being honest and reporting income that she didn't have to, I mean, she was very engaged in the appreciation that she enjoyed in having this voucher that would allow her to house herself and her son. Why would she ignore a notice? And then why would she still be fighting 3 years later to get this back if it wasn't true that she never received the notice? And I think it's very relevant and very compelling that 3 entities are supposed to be aware of this notice. Well, I'm calling Miss Fry an entity, but Miss Fry, the voucher agent who administers her voucher, and the housing complex where she lived, none of them behaved as though they had received a notice in September saying that her housing had been terminated. So I can't explain why Mishta is so convinced that she received notice, but I'm very confident that she did not. And because she did not, I find her very innocent and empathetic participant in the court process. And I think because she did not abandon her unit, and even, I mean, we explained why there were other people staying there. She needed family help because of a family emergency. But the time between her being in communication with the management company and this allegation being made was shorter than the requirement of her notifying the voucher agent if she was going to be absent from her unit. So I just think in this case, she didn't break any rules, and yet here she is 3 years later without housing. I mean, not without housing, but without the income-based housing that she's entitled to if she follows the rules, which she did. So I know there's other things that I wanted to say, but I will just let the court know that what we would, ideally, we would love it if this court just decided that all of this needed to be fleshed out in an ALJ hearing and we could just go directly to that option. But if not, remand it to the circuit court to explore all of these issues and really force them to grapple with the complexity of the facts. And
I just have one technical question, nothing to do with the merits of the case, but did you, I think there's a certification you have to do for the amount of words. I mean, your brief struck me to be, and maybe I'm wrong, but it seemed to be greatly in excess of the limits we impose. And there's a reason we have limits. If you were sitting here all day, you can see we have a massive amount to read every month. And I know your client said this will have nothing to do with how we decide the case. It's a very good brief, so rest assured. But just, maybe in the future, if you could kind of check that, and maybe you did, and maybe I'm wrong, but it struck me to be a very long brief. Maybe too long.
I thought I did.
And if you did, I apologize.
Include the certification. But I thought that we were within, I will tell the court that I was not the original author of the brief. That person has moved on from our organization.
Well, it's a thorough brief, no doubt about it, but if
I'm very
everybody
proud
wrote
to
one that was
be
way too
here.
long, it'd be-
I'm very proud to be here arguing her work because I also thought it was very good, but I apologize if it was too long.
Well, and I do if I'm wrong, but okay. Thank you. You have time for rebuttal too.
Okay,
All right.
thank you.
Your Honors, I'm not endorsed for argument, so if there's any questions, I'm happy to answer those questions.
You want to just put your appearance up here on the record as long as you're here? Ms. McCormick, is it?
Yes.
Okay, well, why don't you officially tell us who you are?
Good afternoon, Assistant Attorney General Shelley McCormick on behalf of the Michigan State Housing Department Authority.
Well, I guess I have a question, which is how is this supposed to work if you miss the deadline because you didn't get notice?
Sure. So as to that question, I think there's 2 avenues, and the trial court dealt with this a little bit in its order. You can file an original action in the proper jurisdiction. I don't know that if you are suing Mishta, that the proper jurisdiction would be Ingham County.
But you could file some sort of a claim of a due process violation, let's say. That's not what was done here. What was done here was a claim of appeal. A claim of appeal under the Administrative Procedures Act requires a final decision in order from the agency after a contested hearing or contested case. So essentially, it was not properly brought to circuit court, and that's why the circuit court lacked jurisdiction. I think.
Is that a little circuitous to say that the court doesn't lacks jurisdiction because it's not a contested case, but it's not a contested case because there was no hearing, and there was no hearing because there's a claim that there was no notice. Like, that seems a very closed circuit argument in terms of just the court having jurisdiction to address the merits of whether there was notice in the first place or not.
So the court's authority to have jurisdiction of an administrative decision is based on the APA, and the APA specifically says that it has to have it has to be a final decision in order. Here, what essentially the appeal was email correspondence with MSHDA's staff attorney. The question to the staff attorney was, could we have a late hearing, essentially, because of these reasons? And the staff attorney answered no. We're not willing to give you the opportunity for a late hearing. So that essentially was the claim of appeal to circuit court. That doesn't vest, according to the Michigan court rules, the Administrative Procedures Act, that does not vest the circuit court with jurisdiction. So to answer the question, I think there's potentially two routes. Council could have filed some kind of a request with the Michigan Office of Administrative Hearing and Rules, because of course that's not an agency governed by MSHDA. That is the Administrative Hearing and Rules Office. And so had that request been made, to be honest, I don't know what would have proceeded, but I can tell you that when I represented other agencies, DHHS, for the Attorney General's office, that we did have cases that came in. It was not a MSHDA case, but it was a program termination case. And there were issues with whether or not the participant received notice. Those went to more decided in their process how to set that for an administrative hearing. And my client at the time, which was MDHHS, they got to decide how to defend that, or whether they wanted to give an administrative hearing or participate in the administrative hearing or negotiate with the petitioner. So I think to answer your question, I think there were two routes. Neither were taken here. What was taken here was a claim of appeal and two motions filed with the trial court, with the circuit court, which were improper. And the court properly ruled that it lacked jurisdiction to do what Ms. Fry was asking.
We used to, my law professor used to call this a bubble hearing, which is to say, there's got to be some way to figure out whether notice was given, because if notice was given appropriate according to the requirements of due process, because if notice wasn't given, then the fact that she missed the deadline is like that doesn't mean that you can't have a hearing. And so I guess I'm just trying to figure out why, where you go to get that bubble hearing. And I guess what you're saying is there are some possibilities, but it's not through the Ingham County Circuit Court.
The problem with remanding the case back to Ingham County Circuit Court is it doesn't have you're remanding it to a court that doesn't have jurisdiction to do anything.
I mean, there was a request for a hearing. It was denied. And then with the denial came a statement that said you have 10 days to request to dispute this.
It was 15 business days.
Yeah. Okay. And then that was done, and then the dispute was denied. And that didn't come in a special official looking form, of course, that came in an email. But what you're saying is that is not a contested or that's not a final determination.
Correct. And I also, in my brief, I addressed if the determination to deny the late hearing, because there was a form that was filled out. You know, of course, this request came a year after the fact. So when we're talking about that, there was a form that was filled out. And so if, for example, the court were to say, okay, we're looking at that as a final decision. I'm not suggesting that my client sees it that way, but if that were the final decision, then of course, under the court rule, they would have had 21 days to appeal that. And that would have been back in 2023. So I mean, the court would lack jurisdiction, the circuit court would lack jurisdiction under those conditions as well.
Okay, well, thanks for indulging my questions.
Thank you. Yes.
This was a contested case. This was the process available to us was to reach out to the legal department. I don't know that it's particularly definitive in this case, but the person who denied this request is the person that also writes the final decision and orders when there actually has been a hearing. But this was a denial of Miss Fry was contesting the termination of her voucher because she didn't get notice. This was the process that was available, was to reach out to legal and make an argument as to why she should receive a final an evidentiary hearing. It was denied, and it functioned to permanently cut her off from getting an opportunity to defend against the termination of her hearing. And as we argued in our brief, the circuit court's obligation in that situation was not to say that this doesn't meet certain I would say, formatic details of a final order. It would be if the circuit court didn't find for some reason that this met the strict four corners requirement of a final order, then it should have been remanded for more development of the record and an opportunity for a final order to be issued that then could be reviewed by the court if necessary, not to just reject it on its face because it didn't reach a particular format. The other, I just wanted to say that the delay, the reason that it took so long for us to make a more formal, robust request is because the FOIA process took so long. We felt that we actually had to know what had happened before we could make the most compelling argument for Ms. Fry. And the other thing that I forgot to mention is that MSHA, it's not just the APA. MSHA's relying on the APA as though that's the end all be all of what is required in this case as far as their legal duties and such. But they are controlled by federal law. And the federal law requires them to provide proper notice, and the federal law requires the hearing and all of these things. And so they can say that the APA is the only thing that you should look at when you make a decision in this case, but the federal law overlies it and is actually creates a heightened duty in cases such as this. I just wanted to also comment, the circuit court said that Ms. Fry was just trying to get a second bite at the apple. But I think that in these situations, an individual that's wronged by an agency decision and has provided credible evidence of that fact is more credible than an agency who hasn't provided any credible evidence that they complied with federal law and their own policies. And Miss Fry lived through this. She knows exactly what happened. And she kept everything. And we've tried to litigate her version of events, and that should be given a lot of weight in this process.
Thank you.
Thank
Case
you.
will be submitted. Item 11, docket 376558 is Michael Joseph Letvin versus the Village at Grand Traverse Common Condo Association.
Good afternoon.
Good afternoon.
May it please the court. Chris Barata appearing on behalf of the plaintiff appellant. Your honors, I'm conscious of the late hour and the delays, so I'm just going to try and hit the high points from my brief.
Listen, it has been a long day, but you've waited a long time. So if you have more to say, don't
It's
let
certainly
that be
past lunchtime, Judge Kelly. But
Facts were good,
Yeah,
so
yeah.
please
Seriously,
take the
I
time
mean-
that you need.
all right.
It's a long time to get here, okay? And I don't want someone leaning and say, geez, they looked hungry or something, so I cut my argument short.
It's a long time to be here, as is always the case, but we'll go through the facts and the law and the application there too. So in the trial court, the defendant argued that the plaintiff was a guest of the condominium owner and therefore was a licensee. The trial court relied on Gabrielson versus Woods Condominium Association and Francis Scudi versus Fox Chase Condo Association. The plaintiff's motion for reconsideration in the trial court indicated that Gabrielson was abrogated by the Supreme Court decision in Giannini versus London Townhouses, which overruled Francis Scudi. So Giannini is a Supreme Court case that came out on July 11th of 2024. And what the case held is that if there's a condominium association that's responsible for the common areas, which is identical to Grand Traverse Commons in this particular case, and the co-owners lack possession and control of these areas, which is also applicable to this particular case, then the co-owner is an invitee when using the common areas. Also, the same analogy and the same facts in this case. The trial court relied on Gabrielson, which had relied on a case called DeBoard versus Fairwood Villas Condo Association, and the dicta stated therein that a social guest of a condominium owner was a licensee of the condominium association. Gabrielson held that same thing. We then have the case of Francis Scudi versus Fox Chase, wherein Francis Scudi held that a condominium owner could not sue the condo association because the unit owner was actually a co-owner of the property. So it was this legal fiction where the plaintiff's neither an invitee nor a licensee, they're a co-owner and you can't sue yourself. Giannini overruled Francis Scudi, and we know now that when a co-owner is on the common elements of a condominium association, that the duties owed are that to an invitee, which this court knows is afforded the highest protections under the law. So the significance of Giannini in the present case is as follows, Your Honors. In this case, the unit owner was allowed to rent out that particular unit to persons such as the plaintiff. The permission to lease the unit to non-owners was a component of the unit and also was a benefit to both parties, both Grand Traverse Commons as well as the owners of the condominium in this particular case. There was a business relationship between the owner of Unit 302, which Michael Levin rented, and there was a business relationship between the owner of 302A, which was rented, and Grand Traverse Commons. Plaintiff leased the unit, albeit for a short time through Airbnb. He became a tenant of the unit owner. In Giannini, I found it interesting that Giannini said, quote, "In this case, the landlord-tenant relationship mirrors the relationship between a condominium association and a condominium co-owner." I would cite to this court, which I don't believe it's in my brief, the case of Stanley versus Town Square Co-op, which says that.
Found it.
I'm sorry.
We found it.
Oh, excellent. Which says, obviously, then you know that a guest of a tenant is an invitee to a landlord. I think the same analogy is applicable here. So assuming this court agrees with our position that plaintiff was in fact an invitee when he fell on the common area, the Stella lot as it's known in this particular case, we would argue that the motion for summary disposition that was granted was completely improper. The judge, the trial judge said that this was just an ordinary slip and fall. It's up North Michigan and it didn't, quote, shock the conscience of anyone. Well, that's not the standard. We know that that's not the standard. You also know in the record that the day I filed my motion for reconsideration, it was summarily denied within hours by the trial judge. I have no explanation why. Candle El Sayad clearly indicates that there's a duty to inspect to invitees and there's a duty to repair. The question, the record in the trial court, the testimony presented, there are multiple issues of fact which preclude the granting of summary disposition. So for these reasons, we feel that the trial court erred in classifying the plaintiff as a licensee, and we feel the plaintiff is an invitee, and accordingly, flowing from that, summary disposition was improper based on the recent case law of Candle El Sayad. If I would reserve 5 minutes for rebuttal. Thank you.
Good afternoon, Douglas Curlew, appearing on behalf of the Village of Grand Traverse Condominium Association. As the court knows, the basic principle of duty is that duty is based on the relationship between the parties. What we've got here is confusion on the part of the plaintiff as to what the relationship of the parties is. As the words from counsel's own mouth just a moment ago was that Giannini says a co-owner is an invitee in common areas. That's fine. Mr. Letvin wasn't a co-owner. He was a renter via B&B from a co-owner that we've never identified and is never not known to Mr. Letvin or identified. And there's this statement that there's this permission somehow for this co-owner to do this Airbnb rental. There's nothing in the record that says that. I based my brief entirely upon the record that was created in the appendix from Letvin. There is no evidence was ever generated to establish what rights or options or permissions the co-owner had to rent or use to other persons of this unit. As far as the record shows, Letvin was a complete stranger to the condominium association. There was no relationship at all. Gabrielson.
But just moving up to that, the landlord tenant case, I mean, that a guest of a tenant is an invitee under that, right? Was it Stanley?
Stanley.
Yeah.
Stanley. I haven't looked at that one.
That's an old case, if I recall, from the 90s or something, right?
Yeah, I remember.
So I mean, that proposition isn't anything really new under premises liability law.
I have not looked at the Stanley case in a long time. I used to do all premises liability. My previous firm, it was what my bread and butter day, and I haven't looked at Stanley in a long time, but that sounds familiar.
So if Stanley says that, and Stanley was cited in Giannini, by the way. So the Giannini court knew about Stanley, right, and they cited it, I'd say, approvingly. And so you're right. Giannini didn't explicitly address this scenario, but it just seems odd that if the guest of a tenant is an invitee, if they're injured in a common area controlled by the landlord, and they're considered an invitee of the landlord, now that we have Giannini, wouldn't it be real odd to say that an Airbnb guest who's injured in a common area of a co-op is not an invitee of the condo association?
Well, two quick rebuttals to that, or re-rationalizations of that. In Stanley, you had a genuine guest. Here you've got some kind of odd commercial relationship via B&B between Letvin and the actual owner that we don't even know that the owner had permission to do. So this person could, from the perspective of the association, could actually have been a trespasser, absent proof that of what the status was, and it was the burden of Letvin to prove the relationship at the time. And we've got Gabrielson, which is the situation where, in fact, the owner did have express permission to have this person renting the room from them in their unit. And yet this court said in Gabrielson that that person is only a licensee as to the association. So we've got the more recent case in the exact same situation, whereas Stanley has somewhat different facts, just like Giannini does. You've got a guest. In Stanley, you've got a co-owner in Giannini. Here in Gabrielson, which is the recent case by this court, we've still got.
Gabrielson decided before or after Giannini?
I'm sorry?
Was Gabrielson decided before or after Giannini?
Gabrielson was decided in July 2024. Excuse me, Giannini was decided in July 2024. Gabrielson was decided in January 2024. So it is the later opinion.
Gabrielson cites Francescuti, which is explicitly overruled by Giannini.
That's correct.
And I think one of the questions before us is whether Giannini effectively abrogates Gabrielson, even though it doesn't sort of explicitly overrule it, right?
But again, both those cases, I can't pronounce it, Francescuti and Giannini both deal with co-owners. And here we're dealing with this odd situation that Letvin never could describe and never offer any proof of, where he's the Airbnb renter from someone he doesn't know through this unit, where we don't know what relationship or what permissions they had to do this.
Speaking of that, whose burden is that?
Well,
you represent the condo association.
Sure, that's
Wouldn't that be an
correct.
affirmative defense to say that, hey, listen, the rules specifically say no Airbnbs?
Nope.
He says I was there.
Duty depends on status and relationship and status, and the burden of proving status is on the plaintiff.
Well, he says that he had, he's running this Airbnb. How do you rebut that?
He said, you can
Again,
rent.
you represent the association. It seems like you would have a copy of the rules.
Right, but we don't rent the Airbnb.
Okay, but the rules, all condos have association rules, might say, hey, no rentals, no Airbnb. Some of them say that.
Some say some don't, but Gabrielson, they did give permission and that was okay with them.
But why didn't you bring that up?
Well, it was their burden to prove whether we had the relationship, and he couldn't describe his relationship. We don't even know. I mean, we have rules, obviously, but whether the rules gave permission to him is unknown.
I mean, I think he established that, he was there with the permission of the
Airbnb.
You're saying the condo unit owner, that was not a.
There's no proof of that he had that he was a complete stranger. He was unknown to the condo association. The question is, what's the relationship between the plaintiff and the association, the defendant? Airbnb is not the defendant. The unit owner is not the defendant. We're talking about the association as the defendant, and we've got to find the relationship between them.
He's a guest of the owner.
No, he's a renter through Airbnb. Who knows whether the owner even knew he was there? The owner could just own this.
Maybe we're getting into what Airbnb is, but I think it's implied if you swear in a deposition that you rented a unit through, not from, but through Airbnb. I think you're basically saying I was there with the permission of the owner of that property. I mean, isn't that kind of how it works?
Well, we're saying kind of how it works. We're guessing. That was something
I think we're drawing reasonable inferences from the sworn testimony.
It's the burden of the plaintiff to prove his status as a licensee or invitee. That's the meat and potatoes of his case. And so he's the one that's got to explain what the relationships are between them, and he's got to prove it. That hasn't been done in this case. I mean, we can't just say, well, on reasonable thinking, this was probably, the burden of proof is on the plaintiff. He's got to show got to connect the relationship between himself and the association, because the association is the defendant. I mean, he could have sued the owner of the unit. He could have sued Airbnb. He chose to sue the association. And so he's got to connect the dots to show that direct commercial relationship under STIT.
What theory could he sue the owner of the condo on? They didn't have possession and control of the lot.
Well, as you see in the Giannini, the condo owners are the collective who, in the association. So you could probably sue him, I think, or, I don't know, but you could sue somebody else. The question though is whether you sue the owner or sue Airbnb, you've sued the association.
But your
You've got
brief
to make the
doesn't-
direct connection between the association and the plaintiff.
Doesn't your brief say that he's a licensee? I mean, it doesn't say
Yes,
that he's a
he's-
trespasser.
No, he's not trespasser, he's a
Okay,
licensee.
Well, if he's not a trespasser, then presumably he has some sort of relationship through Airbnb so that he's allowed to be on the property.
Well, he's allowed to be in a common area, even if he wasn't running a unit. Remember, this is an area of retail establishments, condominiums, restaurants and things. So anybody can be in a common area and be a licensee, just like being on a public sidewalk. So it would be hard to argue there wasn't properly a licensee.
Because it's open to the public.
Right, but as a licensee, we've met the duty to the licensee. Well, the question is, can he show he's an invitee, which is what he wants to do? And to show he's an invitee, he's got to connect the commercial dots between himself and the association. And that's what he hasn't connected. Does the panel have any more questions?
I don't.
Okay.
I don't.
Thank
Okay.
you.
Thank you.
Is that it? Okay, all right, great.
Thank you, Your Honors. So, Brother Counsel posited the question to the court that Michael Levin wasn't even known to the association, his comings and his goings. What difference does that make? The association doesn't know what the condominium owners are doing on a daily basis. This is a defense about getting out of your duty to maintain and inspect a lot. No condo association that I'm aware of in the world keeps track of the comings and goings of the individual unit owners. That doesn't mean anything in this case. I took the deposition of the president of the condo association. I took the deposition of the president of the development company. I looked at the bylaws in this case. Guess what? No testimony that renting through Airbnb is prohibited. No testimony that this wasn't allowed, that the plaintiff was doing something that he wasn't supposed to, that the unit owner of 302A wasn't doing anything that they were supposed to be doing. And so what difference does it make if Mr. Levin is a tenant, if he's a guest, if he's a co-owner, if he's a guest of a co-owner, or if he is in fact a temporary co-owner by way of his rental through Airbnb? He is in fact an invitee under all applicable analysis by this court, and most particularly by the recent case of Giannini. Does the court have any other questions? Thank you, Your Honors.
Thank you. Thank you. Interesting issue. Item 12, docket number 378143. In petition of state treasurer for foreclosure for unpaid tax. Oh, thank you. Which is consolidated with docket number 378144. Same title. Thank you, Judge Patel. And docket number 378147. All three cases are consolidated as item 12. Go ahead. You can tell it's been a long day.
Yes, Your Honor. Good afternoon, Your Honors. Assistant Attorney General Brian McLaughlin on behalf of the State Treasurer. So, Your Honor, in these consolidated cases, we filed supplemental authority addressing this court's opinion in Gordon Beck, which is docket number 376481. which requires that this court reverse in this matter. So this case has several motions filed under MCL 21178T, which is a statutory mechanism that was enacted in 2020 to allow people that had a tax foreclosure make a motion to get proceeds for the surplus. So Beck involved applications for leave from a denial of the state treasurer's motions for summary disposition involving the three claimants here, Deaver, Nicholson, and Webster, on their motions for proceeds under MCL 211.78T. The cases involved before the panel today is claims of appeal for these three claimants under a final order for MCL 211.78T. So the Beck opinion already addressed the same issues that are before this court, just a difference of whether it's the application for leave on the denial of the state's motion for summary disposition, or if it's the claim of appeal from the final order. So what Beck held is that Beck reversed the Livingston County Circuit Court and remanded for entry of summary disposition in favor of the petitioner. So Beck controls the outcome in this case and requires reversal. There is somewhat of an outstanding issue that this court need not address, but may be worth identifying in the petition. So the possible outstanding argument is that MCR 7.202 subsection 6A6 addresses what is a final order for these types of motions. And it would appear that the typical rule for finality would be a claim of appeal from a order for proceeds under 78T would pull in these prior orders at summary disposition. But it's unclear because there's a lack of case law on it because this area is new and developing. So there is a possibility of that issue being raised in this opinion, but it's, to be quite honest, if the court did address it, it would just end up being dicta at this point. Beck is a published case. It's the same three claimants as this matter here, and the court already required entry and order of summary disposition in favor of the state treasurer. So, Your Honors, unless you have any questions, I would just say the remainder of my time for rebuttal. Thank you, Your Honors.
To please the court, Donald Visser on behalf of the appellees. I really feel like I probably should be getting the other seat today after Beck, but let me address a few things as I see from the Beck decision, which is a published decision addressing and reversing the underlying decision of the trial court. I don't think it covers it all, but I think importantly, this court needs to know that we're in the process of preparing a motion for reconsideration. It raised a number of issues. I would ask that the court consider holding its decision in abeyance pending resolution of the motion for reconsider, but I'm going to address a couple of issues that I see so the court kind of knows why I'm concerned about the underlying decision. The underlying decision seems to treat the MCL 211.78T as a procedural posture and not as a substantive creation of a right, and links the statute of limitations to the underlying constitutional claims for a taking, and this particular, and indicating like for Beck that the sale occurred in 2014, therefore the statute of limitations would be based upon that. The problem that we
Mr.
have.
Visser, I'm sorry to interrupt. Do you agree that if your motion for reconsideration in the other case is not successful, then we're bound by what happened in the other case?
I believe you are bound by the other case. I think you.
So the points you're making now are they're going to be directed to the other panel.
They're going to be, some of them are going to be directed. I don't think all of the things are addressed here, and I would ask this panel to issue a decision, if it does issue an opinion, saying we're bound by the Beck decision, but we disagree with it. And part of that goes, if you look at when the Beck panel tied the decision to the underlying cause of action, the accrual of the underlying cause of action for a constitutional tort of taking, it then ignored the fact and said this is just a procedure for getting the remedy. It ignored the fact that if it were in fact the procedure for getting the remedy for a constitutional taking, then the statute would have to award 100% of the taking and, in accordance with prior state case law, interest on that. It doesn't. So therefore, the problem is it's not just procedural, it's a change. It makes a little bit of sense if it's procedural, but now because it doesn't award the statute doesn't award what would have been ordered under the Constitution, it is not the same cause of action as the underlying case. The other thing that the panel missed is the fact that if it is in fact a procedural action, then the statute of limitation doesn't apply. Now, this wasn't raised because that wasn't the gist of the discussion there. But if it's a procedural thing, then the motion is filed in the underlying case. If it's just procedural for getting the remedy, and the cause of action relates back to the date of the filing of the complaint, because it's just a motion, a procedural motion, not a substantive motion, which would take it outside that case, but now it's procedural. And all of the cases relate back to the date of filing. And just cite from Labar v. Cooper, which is a Michigan Supreme Court decision from 1965, a very old case. I felt real bad in the prior case where the panel referred to a 1990s decision as an old case, and I just started withering in my seat there because I predate that. But this decision said, it is well settled that the amended pleading can introduce new facts, new theories, or even a different cause of action, as long as the amendment arises from the same transactional setting that was set forth in the original pleading. So that's Labar versus Cooper at 376 Mich 401. So really what happened is the prior panel, in looking at, oh, this is a procedure, then did not address the fact, well, if it's just procedural and saying this is a new procedure within the General Property Tax Act for recovery of the proceeds that you are always entitled to, according to Raffaelli and Schaefer. If that's the case, then there's no statute of limitations application. That intends to be one of our issues for reconsideration, because when we start looking at all of the tentacles of what this is all entailed between Raffaelli and Schaefer and MCL 211.78T, there's a lot of things that don't get considered when we're looking at just one of the issues. And in this case, we have that case did not address it. It relegated it to a footnote. We have non-compliance with the foreclosing governmental unit of the requirements of subsection 7. There was not timely compliance. What does that mean? That means that if you take the language from In re Muskegon County Treasurer, the government, the foreclosing governmental unit, lost all rights, forfeited all rights under to the remaining proceeds. And I would suggest that it's good, what's good for the goose is good for the gander if there is non-compliance. And I brought before this panel in Iron County v. Joseph, the fact of substantial compliance. And no, there's no substantial compliance. So the fact that the that the FGU did not comply with the statute requirements under subsection 7, I'm saying that, and that's not decided by the Beck panel, that means that the governmental unit loses all rights, just like a taxpayer would for failure to meet the strict requirements. Additionally, trust was relegated to just a short comment. We have the issue of estoppel here. And that is, not a promissory estoppel, but estoppel by the actions of the state government here. They've passed the law, they've enforced the law, they've told everybody you can't collect. They've passed another law that says you can't collect until you get a ruling. And it's our position from the city, Adams versus City of Detroit. It does not always require an express misrepresentation, since it also encompasses conduct designed to induce the plaintiff to refrain from taking any action against the defendant, citing Doe versus Roquette and Oliphant versus State. Moreover, where a governmental entity misleads a plaintiff about its rights and subsequently seeks refuge in the statute of limitations defense, estoppel is appropriate unless the government's position reflected a reasonable interpretation of its obligations. Here you have the state has set an unconstitutional statute saying you can't get any relief. And then they have enforced it for a number of years and precluded the parties from ever attempting to get it. So we believe to get the surplus. So we believe that this is in fact a case where estoppel is an appropriate situation. Finally, I'd like to talk about one thing that is not talked about frequently and is avoided, and that is the ramifications of in light of Beck, the ramifications of Michigan's takings provisions in Article 10, Section 2, which is very unlike the Fifth Amendment protections and very unlike most other states. And that is, in 1963, our Constitution added a requirement that took away the ability of government to take property unless it first paid. The federal Constitution does not impact the ability of government. It just simply says if the government takes, it must then pay. And then you have a number of issues over the reasonable compensation for that taking. Michigan's is very different. And in light of what's happening here, you have the taking, you have the surplus proceeds being generated at the date of the sale. And you can't get that ownership over to the government. But the government's asking this court to do that de facto, to violate the Constitution by saying you can keep that money despite the fact that the Constitution says you may not keep the money. The statute itself is even somewhat clear on that. MCL 211.87B 1 says that the treasurer holds it in trust, and for the county application, the county has no claim to the money at all. So the question is, after the sale, how does the ownership of this property transfer, not possession, ownership transfer to the foreclosing governmental unit? The Constitution says you cannot take it. Raffaelli gives a little bit of homage to that statute. It says the Constitution impacts the ability of government to take. So if they have no ability to take, how can they come before this court or any court and say, we are going to de facto do what the Constitution prohibits? And that's a real problem, I think, in the context of this case. And I think what you end up with is what this court did in Miller versus the Michigan Department of Resources back several years ago, and said, if you don't follow the mandatory procedures of the Uniform Condemnation Procedures Act, then you have an unlawful possession. And if you have an unlawful possession, that's a continuing thing that continues. And when the continuing unlawful possession is within the statute of limitations. Now that was not presented in the back case. And we have, in this particular instance, we do have that situation where if you apply what the Constitution says, you can't get there from here. And if you go and allow this statute to do and allow the government to keep money where the claimant says, pay me my funds, you're actually allowing a statute to accomplish what the Constitution says is unconstitutional. And we would, therefore, we would ask that if nothing else, hold your decision until Beck is decided. I am fairly confident if they grant the motion for reconsideration, the state will probably file an application. And I know that the flip side, if they don't, our office will file an application on that. But that's what I'm seeing, the broader tentacles, the issues, which makes Beck kind of a very, very difficult pull when you start throwing in the Constitution and the mandates of Michigan's takings clause. I don't know if the court has any questions. I always prefer it when the court does. Thank you, Your Honors.
Your Honors, just a couple of brief points. So Beck did not actually classify MCL 211-78T as some sort of just procedural vehicle. What it did is it looked back at Schaefer and said Schaefer's holding was that 2878T is retroactive for basically not replacing, but allowing these constitutional claims to be brought against the foreclosing governmental units. But Schaefer had to recognize that they had to develop a fair way of addressing retroactivity. And Schaefer's main holding, to be summarized, is that 211-78T didn't revive claims. If they could have been brought under Raffaele under that theory, they began to run when the claim accrued, and claimants, if they had any balance of time when 2878 MCL 211-78T was enacted, claimants get the balance of their time under the old theory. So the other point is Muskegon County Treasurer, that really doesn't have any application here. That case was an opinion from this court. It did not address forfeiture for any sort of perceived error by a foreclosing governmental unit. That case was really premised on a main theory that the notice of intent requirement under MCL 211.78T subsection 2 was basically that there couldn't be, the failure to meet that couldn't result in a forfeiture of your surplus proceeds, that you essentially have an automatic right because of these constitutional arguments. This court essentially rejected those arguments. So, Your Honors, unless you have any further questions, the state treasurer just asks that you reverse the circuit court here. Thank you, Your Honors.
Submitted and brings us to our last case, item 13, docket number 376273, and Ray Davis minors. No.
May it please the court, Jerry Scrotenboer, Ingham County Assistant Prosecutor for Petitioner Appellee. As no one else is here, I'm relying on my brief, asking that you affirm and ask if you have any questions.
No questions for me? Not for me. Doesn't appear so. Thank you for
Okay,
appearing
thank
as
you.
always. And have a good day.
Okay, thank you. By the way, this is not the record today. I once had it at 2:45.
We'll keep trying.
Okay. All right, that concludes today's call. We are adjourned until tomorrow morning.